Oh, that yesterday, that matter. Okay. Mr. N. Decca, Learned Counsel for the Learned Standing Council, Indian Oil, Learned Counsel appearing for the Indian Oil Corporation Limited respondents submits that the instructions required to be received by him to clarify the queries raised by this court on the last date of hearing has not been received by him till date. He prays that the matter be taken up on court on 4/12/2025. So prayer accepted, raised to list this matter again on 4/12/2025. Yes, Mr.
I have filed affidavit and IA for the item number 32, Lordship.
One fourth. You are for the petitioner. Who is your senior? We'll hear the petitioner. You could have circulated a note yesterday. Dishilni, 14 Dishilni, okay. A prayer is made on behalf of Mr. S.K. Medi, Learned Counsel for the Learned CGC, appearing for the respondents for an adjournment in the matter on account of, on the ground that he is out of station. So prayer is not objected to by the Learned Counsel for the respondents, for the petitioners. So accordingly, registry to list this matter again on 8. When will he be here? On 9/12/2024. No further adjournment shall be granted in the matter. 15 matter disciplinary proceeding. 9. You signed the undertaking. I forgot, but I read it. Anyway, fine. Matter. The Learned Counsel. Mr. Majumdar Chaudhary, we'll have a week time in Kohima, so we'll pass these orders in Kohima. 1, 2, 3. Heard the Learned Counsel for the parties. Hearing concluded. Registry to hearing concluded. Judgment reserved. 2 p.m. 2 p.m. File today. Correction. We have considered the submissions of the Learned Counsel for the parties, and we are of the considered view that the petition is devoid of any merit, and the same accordingly stands dismissed. Some corrections are there. You will have the copy today or by tomorrow. Duterte, same order. Ms. MS D. Gugoi, Learned Counsel for the petitioner, on instructions, pray that the submits that the petitioner is not desirous to proceed with the matter any further. Accordingly, she prays that the writ petition be permitted to be withdrawn. Full stop. Prayer is not objected to by the Learned Counsel for the respondents. Full stop. Accordingly, the present writ petition stands dismissed on withdrawal. Next 2 to same. 7 also same. Mr. Bora, Botago, we take up the matter, we'll dispose it of today. So you get hold of Mr. P. Monto. You get hold of Mr. P. Monto. You are questioning the very initiation.
My ground, your lordship, that ground, that is your the
Because yesterday I saw the condition of the file. It cannot be kept anything more. It's very serious. Ventilator.
first ground is your lordship, the main defect in this disciplinary was your lordship was issued by the inquiry officer himself, your lordship, not by the disciplinary authority. Mandate
Governing
of the no, first ground, your lordship. Secondly, your lordship, substantial ground that has not been pleaded in this petition, but your lordship, that is will be the 21 of the Assam Pension. I'm relying on that, and my point is this, your lordship.
When was the proceeding?
Your lordship,
When did you? Okay.
I retired on your lordship 39/2010, your lordship. 39/2010 I retired, and SOCOS was issued, your lordship, thereafter, your lordship, on 15/2/2011. Now, by the time, your lordship, this is issuing a SOCOS notice,
So you retired on
39/2010. SOCOS was issued on 2011. I was suspended on 19/5/2010, your lordship, prior to retirement.
the suspension order was not revoked.
Meanwhile, I retired, your lordship, then they issued.
But you participated in
I
the
participated. I participated in the discipline. I have specifically found that this discipline, the fact that the inquiry officer himself had, and therefore this is cannot be continued. Apart from that, your lordship, there are other grounds that report was not submitted, your lordship.
that we will come
And then, your lordship, that they have relied on certain documents, your lordship.
that documents.
furnished to
But
me.
we'll take up everything together. So basically, this is the scenario. And you also allege that provisions of Rule 21.
Sanction of the governor will be required, your lordship, if they want to continue the retirement, your lordship.
Okay. No adjournment. We are hearing this matter. No, I'm sorry. Today you will hear it because last date we accommodated because of you. We have taken up the matter. It's a matter of 2013. You understand? Then you do. Otherwise, we'll say none has appeared. When you argue, please. Fine, you don't insist. You have a battery of last date. The adjournment was taken on the ground of Mr. S. Bhuya. Today, Mr. We can't. We have your affidavit. We'll consider that. No. Today, 2:00 maximum, not beyond that. We can't. We don't know. We had granted time last time with specification. Mr. Bhattakur was very insisting. It's a question of law. We'll consider it. So if your name is there, don't appear. That's all. Don't appear. We can't help it. Mr. Odikari, last time we made this prayer. If you had any problem, you should have informed us yesterday. Then we can't help it. We can't help it. I'm sorry. This matter is getting adjourned day after day without anything. We are hearing it today. So not even a single minute. It goes inside, it will come out today.
After 2, at 2.
Whenever it's convenient to you. I'll wait till 2. No problem. Yes, you make alternative arrangements. Yes. Okay, Mr. And you are just the approving authority. The authority is Mr. Mohanto. He is here. No, it's okay, Mr. Mohanto. He wants an adjournment, which I have denied. Because on the last occasion, the matter was fixed today with the understanding that the matter will take up. We have come prepared. I can't help it. Yes.
Now, your lordship will kindly note one more aspect, your lordship.
Hmm.
After 2005, your lordship, the college was provincialized, your lordship. As per the 5 Act, the provincialization, I became, your lordship, my appointing authority and director of. Now, ultimately, your lordship.
I'm sorry.
Lordship.
That will not be. Because in the 2005 rules itself, the residuary powers, which is not been provided for therein, although the appointing authority is the director, the residuary powers of the appointing authority, which includes the power to power of discipline and appeal,
Lordship.
is delegated to the governing body.
Lordship.
So it's the governing body that has to move against you at the first instance.
Lordship.
You can see the 2005 rules.
2005 Act.
Last page. Rules. Discipline, education manual. Wait. Education manual. Wait. Okay.
Rule 27, your lordship.
Page.
504.
Huh.
That's your lordship. Says your lordship, the governing body of the college.
So here in the rules,
Lordship.
we will find only the power of appointment.
Lordship.
The other residuary powers have been vested on the governing body.
Lordship will kindly see discipline. As per your lordship.
Fine. Here, for the purpose of Rule 15,
Lordship.
the disciplinary authority would be the governing body.
Lordship.
However, once they impose the penalty, because you are now a government servant, the matter has to be placed before the director for his confirmation. And that has been done in this case. So to that extent, there is no. Now, your case is.
My case, first case is this, your lordship, that the charge sheet has been issued by the.
We'll go one by one.
Lord. That is the first ground, your lordship. Your lordship will kindly come to page
Issued by
36.
the governing body.
Lordship. Now, before that, your lordship will find page 34, by which one Jagat Borthakur was appointed as your lordship. Is 34, by which your lordship director appointed
Yes,
then your lordship will find they have appointed principal IC, who is presenting officer also. He appoints your lordship, apparently your lordship. One person called Mr. A. Das, finance and accounts officer, your lordship. On the suggestion of enquiry officer, to assist as a financial expert, your lordship.
yes,
Now, your lordship, page 36. May I read this, your lordship? Departmental proceeding. You are hereby requested to show sign of Assam Service read with Article 311 of the why any of the penalties prescribed under Rule 7 of the aforesaid rule should not be inflicted on you, charges level against you by the management of the court based on the statements of allegation herewith. Now, list of documents and witnesses proposed to be relied upon for providing the challenges, the charges and allegations are enclosed here. To submit your written statement of defense within 10 days from the date of receipt of the communications provided to you. You do not intend to inspect those documents which have relevance with the issues in case you intend to suspect those documents, you should write to the undersigned for the same within 7 days from the date of submit your explanation. Thereafter, within 10 days from the date of completion of the inspection, your written statement stating there to be should be submitted to the undersigned. Within the period specified below, if you fail to submit your written statement within specified time as mentioned above, case will be heard ex parte, your lord. Now, moment your lordship, the enquiry officer issued this search sheet, your lordship, he has already formed an opinion, your lordship. Now, the procedure, your lordship, as prescribed, your lordship, ultimately, your lordship, the show cause under Rule 9 will have to be issued by the disciplinary authority, and my show cause reply will have to be considered by the disciplinary authority. And if disciplinary authority is not satisfied with my answer, then the question of going further with an appointing an enquiry officer will come.
here
Yet that has not
that
taken
role
place.
has been taken over by the inquiry officer.
Enquiry officer. And
by
if
the
moment
undersigned.
is taken over, then this entire proceeding got vitiated, your lordship.
That easy.
Because your lordship will kindly see that my reply will have to go to him, your lordship. You will form an opinion, your lordship, whether to proceed or not on the basis of my reply,
Okay, let us get the facts out of the way.
lordship.
Then what happens?
Then, your lordship, when this was done, your lordship, show cause was issued. I submitted my reply, your lordship.
Page.
Lordship, I will. That is, your lordship, my reply at page 117, your lordship. Was dated 28/4/2011, your lordship. And when your lordship, then your lordship, I also submitted a supplementary,
Page.
that is it, lordship, page 149, statement of defense, your lordship. Precisely, if your lordship comes to page 151, during enquiry, your lordship, they have relied on go through the enquiry report, your lordship will find the most of the charges sought to be proved through the statement of one R. Ahmed, your lordship, who is a witness and who has conducted a preliminary enquiry against me, your lordship, before this proceeding has started.
Good.
Now, no, lordship will kindly come to page 151, and I have specifically stated here that as such, the additional document, he has relied on 116 additional which were not served on me, Your Lordship. As such, the additional document of 160 numbers produced by Mr. R. Ahmed on 9/7/2011 and 5/8/2011 are irrelevant since those were not provided to me. My written statement of have taken that down specifically, which was inquiry officer, Your Lordship. That was one aspect we have raised, Your Lordship. And then, Your Lordship, we
Just-
can come to
And the conclusion of the inquiry officer is based on these documents.
these documents, Your Lordship.
Then-
And then, Your Lordship, inquiry officer submitted his report.
Page 176.
And then, Your Lordship, the matter was placed before the Director Higher Education. Your Lordship will get it that page 259. Now, Your Lordship will kindly,
Where is the recommendation of the governing body?
that was not, that was on the basis of the recommendation of the inquiry and GB's resolution thereon 2010, Your Lordship, by which
The inquiry report is dated.
inquiry report is there. Inquiry report 2/4/2012. Now, Your Lordship may kindly see the order of the Director Higher Education, Your Lordship. Things emerges from this, Your Lordship. On the basis of the recommendation of the inquiry committee, what recommendations and has given is not known.
Very
to-
continued in service.
No, Your Lordship,
You
that's
said
why
that you have retired on
retired on, Your Lordship, that's
30/9/2010.
10,
This order is of 30/11/2012.
12, Your Lordship.
Penalty of dismissal.
Dismissal, that's why, Your Lordship. And in fact, Your Lordship, whether Your Lordship, if Your Lordship, we hold governing body as a disciplinary authority, they will have to pass an order, Your Lordship, on that. There is no reference to it. It only says revise resolution, Your Lordship.
Fine, that might be this. How were you dismissed after retirement?
That that they will answer, Your Lordship, that. And that's why, Your Lordship, I have relied on Rule 21, Your Lordship.
Sorry, exactly. So the preliminary issue which would arise in the present proceeding is, one, whether the charge sheet could have been issued by the
Lordship.
inquiry officer.
One aspect, Your Lordship, I will have got Your Lordship. In the charge sheet, Your Lordship will find at the last
Signature of the
president of the
president.
is there, Your Lordship. But ultimately, Your Lordship, it was
He is non-entity.
Lordship. Ultimately, Your Lordship, it is issued by the inquiry officer. My reply was submitted before him, Your Lordship. And in
The
that,
governor never issues a show cause. It is issued in his name, as like yesterday. First point is that. Second point is that you having retired, whether this proceeding could have been
continued,
initiated
Your Lordship.
without the approval of the
Government.
competent authority. Third ground is that you having retired, now
It would
whether
not
the
have passed
penalty
it.
of dismissal could have been.
Would have passed.
So these are the three preliminary issues. What is there on merits?
So far as, Your Lordship, merit goes, Your Lordship,
Now, first the technical points you can take up. Technical points, documents not given, but findings arrived.
Lordship.
Just highlight.
I have your lordship. So far as your lordship documents, the
Paras and all.
I will para 11 your lordship, para 28 your lordship of my writ petition your lordship. Those. I have made a specific averments here. That the petitioner further begs to submit that Rafiq Ahmed appearing as a witness for the management, long drawn out oral statement, and by using his personal laptop produced 160 numbers of additional documents support of the allegations against the petitioner. In the so-cause notice dated 15/2011, the inquiry officer had provided 172 numbers of documents on which the charges were purportedly based as required by Rule 9(2) of Assam Service Discipline and the Rule 313(1) of the Manual of Departmental Proceeding Government claim against the government servant must such all these 160 additional documents presented to the witness not be rightly taken into account and relied upon by
Okay, fine. What is the harm in taking into record additional documents? There is no bar.
no,
But
but
where is your statement that these documents were not furnished to you?
lordship will kindly see your lordship that when these were your lordship produced your lordship, thereafter I have submitted your lordship an additional written statement your lordship.
Therein you have,
I have.
where have you said that
Lordship will kindly
your
come to
additional
page
written
151.
statement is page 151. You have not said anything. You said that is irrelevant.
Lordship, irrelevant, and your lordship will kindly see para 28, the language, your lordship. What I have stated,
But tell me one thing,
lordship,
Mr. Bhattakur, during when the documents were being adduced,
lordship,
you had the opportunity to cross-examine.
lordship.
Have you taken this plea in the inquiry that these documents cannot be produced because the copies were not furnished to me?
That is why, your lordship, I have submitted para 151 additional.
Fine, but where have you said this? Where have you said this?
Lordship, in fact, your lordship, that since this was
Fact
not
to-
part of your
No,
lordship,
Mr. Bhattakur, you are a seasoned man.
lordship, lordship.
The documents which are initially relied upon,
Lordship.
additional documents can
Additional
always be.
documents can, but that will have to be
That
provided.
show me that it was not given to
Lordship.
you.
That is one statement, para 28, I have made, your lordship.
Para 28 does not say that the documents were not given to you.
Fact, your lordship, the
Para 28 is outright rejected because that is not the correct position of law.
lordship, why I have stated this, your lordship, since your lordship will kindly for a moment, your lordship, if allows me to read para 28.
We are with you.
Me, your lordship. Your lordship, will these lines, your lordship, important? The additional documents in support of the allegation against the petitioner. In the so-cause notice that so-and-so inquiry officer had provided 172 numbers of documents which the charges were purportedly based as required by Rule 9(2) on so-and-so, so-and-so. Charges framed against the government servant must be complete in all respect, your lordship. It means, your lordship, that has not been
No,
provided.
no, you say, see the last line. As such, all those so-and-so presented by the witness could not be rightly taken into account
Account, your lordship.
and relied upon for establishing the. But
Lordship.
where is that statement that without giving you a copy thereof? Because a
Lordship,
copy
that
is given,
specific statement is not
that
there,
copy is
but
given, everything is correct.
lordship,
Because
That-
Mr. Bhattakur, we are considering a man
lordship.
not very, does not give good vibes.
Lordship, lordship. That, that, your lordship, is there, your lordship,
We'll have to consider the matter in accordance with law only. Personal thing cannot come in.
lordship.
But the thing is, he is not overboard. Okay, next, what is the
No,
point? This is not
next,
established.
That is one, your lordship. Then your lordship will kindly, that second point is, second part is, your lordship, that the No inquiry report was furnished to me. That is a rule, that is your lordship in para 34. Petitioner beg to submit that before imposing penalty on the petitioner, this report and respect of the proposed punishment, the petitioner beg to submit that this is the departmental proceeding. As such, in the instant case, the order of dismissal has made requirement. On your lordship, and then your lordship will kindly see come to page 206, your lordship.
Hmm.
Page 206.
Yes.
There is a reference to preliminary inquiry, your lordship.
Was conducted by Mr. R. Ahmed,
Shafiq Ahmed.
and
There is a reliance on that preliminary,
it can be.
can be, your lordship, but that preliminary inquiry report,
Where do I get that?
your lordship, para page 206. Charge was against misappropriation. Fakes, vouchers, distorting original, changing names, so and so. Then, your lordship, against the above mentioned charge, two documents, might exhibit 45, 46, containing confessional statement and so and so.
Okay, I got it.
Before the preliminary.
But was this preliminary inquiry exhibited in the during preliminary
As your lordship, the so far as the
charge sheet was the
charge sheet, there is no reference to preliminary.
and did you cross-examine this man, R. Ahmed?
We have cross-examined.
What is your-
those documents that will be revealed? I don't have that. But your lordship, so far as my statement of defense is concerned, your lordship, there I have made
Okay, Mr. Bothagur,
these are the, your lordship, essential.
take me to the your list of documents in the charge sheet.
Lordship. Your lordship will kindly come to page 36, your lordship.
No, where is the list here? Have you annexed the list here?
Page 36, your lordship, list of documents.
List of documents, charge sheet,
30 number.
annexure. That is, where is the annexure? 55.
Annexure, your lordship, it was not an annexed.
So how do we know that the preliminary inquiry report was not there?
Your-
Or
Your lordship will kindly see that, your lordship, when I have taken certain pleas, your lordship, for the inquiry officer, it is the duty of the inquiry
We got
officer
it.
to
we got it.
deal with
We
that.
got it. We got it. The preliminary inquiry report may not be there, but the documents, statements collected, whether those were part of the list of documents.
Lordship will kindly see from the inquiry report.
Where have you stated that the preliminary inquiry report was not given to you? Or the statements of the
that is
witnesses?
there,
were
your
not-
lordship, I have brought.
Just give me that paragraph. Mr. Gogoi, your higher education department, as far as I know, the residual power of discipline and appeal is with the governing body. So governing body conducts the inquiry, although they may take an approval. The residual power is with the governing body. Preliminary part, the inquiry can be conducted, charge sheet can be issued, inquiry can be conducted. Thereafter, the matter has to go before the director for imposition of penalty. But recommendation can still be made. No, that is why the beauty in Rule 27, the other residual powers of the appointing authority given to the governing body. So the rule only reserves the power of appointment to the director. The rest is given. But yes, the penalty is to be informed, but a resolution is taken normally. A resolution is taken. Now maybe you have refined that. It's the correct procedure. Now tell me one thing. No, I don't. I'm not asking about this case. I'm asking as a standing council, education department generally, because you had informed me earlier also once. Now tell me, in your education department, is the pension rules applicable? Now, a person after retirement, the cessation of the employee-employer relationship occasions, there is no employee-employer relation after that. Now, what can you do? Once a person retires and you want to institute a proceeding, forget, I give you that benefit that you don't take the approval of the governor. That means the government. No, the proceeding is after the retirement. Cannot be. One. Two, the authority has to issue, because in terms of the rules, okay, forget it. Now, if the charge sheet is not issued by the following the mandate of Rule 21, nothing is in it goes. We need not even go further. One more question. Discipline appeal rules will apply, provided the proceeding is initiated under 21. Thank you. No. Here, the director has given his approval. He has asked the governing body to do the needful. And accordingly, the governing body is a big body. Forget it. That we will not go into. We will not question the action taken by the governing body and the director of that point of time. We will see whether if the power is also given to the college to do that, whether they have done it in the proper manner. That much only. Thank you. Yes.
Para 8, Your Lordship.
Of the?
My writ petition, Your Lordship.
You were not a part of the inquiry.
Preliminary inquiry, Your Lordship, I was never a part, Your Lordship.
That you need not be. Preliminary inquiry.
That's why, Your Lordship.
I want that. Where is the document of the allegation that the
inquiry was held from so and so without allowing the petition,
Fine.
and no report of the inquiry is furnished to the petition.
that is before?
No, Your Lordship, Your Lordship.
No, the show cause came after that. Your show cause comes in para 13 only.
Lordship.
So after para 13, where is that?
No, Your Lordship, it has, I have stated, have I received it even during, Your Lordship, during the course of disciplinary proceeding? Then
That
also
is
I would
stretching it
have
too
made
far.
this statement, Your Lordship.
That is stretching it too far.
No, Your Lordship, that has not been provided to me. And Your Lordship will kindly see, had this been the case, Your Lordship,
Okay.
Lordship,
Rule 21.
Lordship,
What is the decision?
Lordship. Your Lordship will kindly come to Rule 21 decision, Your Lordship. In fact,
My Lord Justice A.H. Saikyas.
no, that is not, Your Lordship. I am relying on two. One by division bench, Your Lordship, T.N. Singh and S. Hawk. Another by Honorable Justice Onima. This has dealt with Rule 21, purpose of an object of Rule 21. Your Lordship permits me to read your. I will take
Division bench.
3 paragraphs.
Yes, please.
First, Your Lordship will kindly come to para 11, Your Lordship. Then we'll go to para 13. What is the nature and power conferred by Rule 21? What is the ambit and scope of the power? How is the provisions to be interpreted? are the crucial questions which falls for determination in this case. Must therefore first bear in mind the golden rule of interpretations that in the construing any statutory provision, the object of the enactment first and then that of the provision concerned should be evaluated for calling for judicial interpretation. Indeed, the concerned provision must be viewed in its context, setting for the purpose. Reference may therefore be made to some other relevant provisions of the pension rules which may throw light on its object and also the object of Rule 21 in particular. Section 4, Chapter 5 of Rules deals with superannuation pension, of which Rule 95 prescribes the procedure. It appears from this rule that head of the department is required to prepare a list on the 1st January of each year. All officers gazetted, non-gazetted who will attain the coronation in course of the calendar year. As soon as the list is prepared, an intimation shall be sent to every officer due to retire during the next year to enable him to submit a formal application for pension as required by Rule 184. From a perusal of note 2 appended to the Rule 184, it appears the authorities sanctioning pension should ensure where gov dues are outstanding. Then your lordship may skip, your lordship may directly come to para 13, your lordship. We may now address ourselves to the core question. What is the object and purpose of Rule 221? What precisely is the ambit and scope of Clause A thereof? That pension can be claimed by a person who has been in gov service and is no longer in service is beyond doubt. That it is the statutory right is also clear. Pension rules obviously dealt with this right. They do not deal with the rights of any serving gov servants relating to his condition of service. Can we therefore read Rule 21 as conferring power on gov to punish the ex-employee for anything done by him while in service and for that matter continuing a disciplinary proceeding with that object though initiated before he ceased to be in service, your lordship? This is important, your lordship. The language of Rule 21 itself does not suggest that it has this object in view. The object of the real rule is to be gathered from cognitive provision to which we have referred above. It deals with some of the cases and circumstances in which gov can refuse either wholly or partly in the manner prescribed therein the claim of pension laid by an ex-employee. Therefore, an affirmative and positive action must be taken under Rule 21 by the authority competent to act thereunder. According to us, Clause A and B provide the modalities for taking action under Rule 21. They need not be read as provisos in the technical sense. We do not and indeed cannot read Clause A to mean therefore.
This is not helping you.
What's it?
This is not helping you.
Lordship.
Pension rules. To some.
Lordship.
This is how a pending proceeding can be taken forward.
Lordship.
The rules were thereafter amended.
No, your lordship, that is why I have brought the other judgment.
This is not going to help you.
No, your lordship, here your lordship, certain, the object of Rule 21 is there, your lordship.
Rule 21, that need
No, your
not-
lordship, there are certain,
You come to, this was incorporated, I think after this decision
yes, your
in
lordship,
89.
I will show that.
89.
I have, that I have.
So
seen.
this
I-
decision will
No,
not.
your lordship will kindly come to, just for my satisfaction, your lordship, certain observations, your lordship, that will, even if there, that is why I have pointed out, your lordship, if it is, your lordship will kindly see, resurrected, this, your lordship, this provision is not meant according to us to resurrect a dead proceeding, a proceeding which could only be coextensive with the tenure of service of the employee. In Clause A is construed to mean that in virtue of thereof a pending proceeding against an ex-employee must be continued, and then in all cases, in all pending proceedings, that this must be done in anticipation of an action to be taken under Rule 21 by the competent authority, whether or not such action is warranted thereunder. The construction would certainly produce an absurd result. Besides, there will be scope for the complaints of arbitrary action if such proceedings are not continued in all cases and the disciplinary authority in its whim decides to pick and choose. Such a construction must therefore be ruled out as it would be unconstitutional. We must view this matter also from another angle. Rule 21 expressly confers power on the governor of Assam to take action thereon, unless therefore such action is contemplated by him. The authority which was holding the inquiry prior to the requirement of the gov servant will have no jurisdiction to continue the proceeding. If it does so, it will tantamount to his exercising the power under Rule 21, which expressly is conferred on him, but not on the governor of Assam. This effect of Clause B mandates sanction of the governor to be obtained for a de novo proceeding supports this view. So also the fact that Clause B bars action in respect of events beyond 4 years, which also can be similarly considered by the governor. Indeed, expression omission this requirement in clause A makes constitutionally fragile, and only by interpolating consideration of the same circumstances by the governor in taking decision, the virus of unreasonable nexus can be removed by prevent challenge on this score. Now, your lordship will kindly come to para 14. Why, your lordship? Ultimately, your lordship will find that the logic of this judgment is this, your lordship. Your lordship, when the charge sheet is issued, your lordship, it says the penalties mentioned in Rule 7, your lordship. Why this will that the withholding of pension or anything else is not a penalty, your lordship, that can be imposed, your lordship, after retirement, your lordship. That is why, your lordship, this has very succinctly, your lordship, stated this. Your lordship will kindly come to para 14.
Mr.
No,
This
your
does not
lordship-
appeal to me, and this will neither improve your case nor destroy your case.
No, your lordship will kindly see, your lordship.
Hmm.
There is an intrinsic evidence written in Rule 21 itself, which is to be read as a whole to indicate that the expression shall be continued does not carry in it any mandate. Because the nature and object of the proceeding under Rule 21 is entirely different, the pending proceeding, even if continued, cannot end in punishment contemplated under the Discipline and Service Rule 7. Rule 7 of the service rule contemplates different kind of penalties which may be imposed on a government servant. Although,
Mr. Bhattakur, why
Oh.
are you troubling yourself with all those? Because the rule itself
Oh.
is very clear. Rule 21, if you come to Rule 21,
Just because this is something
no,
before one thing. Before the 2010
hmm.
rule.
So the whole proceeding goes.
goes.
So we note that and we dismiss it. Mr. Monto?
Otherwise, if we go by the 2000.
But what do you say about Rule 27 then?
Power.
You read that residual power. Where is that notification or something that the proceedings will now only be initiated? That came subsequently much later. 15 I've seen. The discipline, it only says discipline and appeal rules will apply.
Selection.
No, selection also the rules mandate that. In the rule, you will not find the rule giving the jurisdiction of power to the director. The power is to the governing body. And I've seen many cases.
One.
Hmm. Then what happened? Om Prakash. This one?
Rules was it that
I appeared or I decided. Appeared.
that. How low sit down? Yes.
No, we'll provide for that. We'll Mr. Gogoi, we can't go beyond the brief. What is here, we'll decide it. Okay. Mr. Upamannyu's name. We'll come to you, Mr. Monto, we are coming to you. Yeah,
Now,
that
your
is done.
lordship, If it goes, your lordship, then.
These two will not come in because Rule 21 opening line is very clear and the explanation in 89 that was brought on is, will
But-
not go and disturb the.
No, your lordship, just for your lordship,
Which
that
one?
this judgment, your lordship, after in 2010, relied on this, your lordship.
That, my lord, Justice, Hazarika's judgment is again also para 14.
Para 12, your lordship may first read, your lordship.
This is not required because this again is of a, this was a wrong, this will be unfortunately not applicable. You read para 14.
Lordship, the
admitted
admitted
position
position is
taken,
that instance there is no decision by the Governor of Assam Rule 21, and indeed no show cause notice has also been served on the petitioner informing him that the proceeding initiated against him in the year 1994 shall be continued in terms of Rule 21.
because that is not required after 89.
Lordship.
After 89, the rules have been amended. You have the pension
No,
rules.
that is
So
why.
that prescription is not correct.
Lords,
Yes.
I leave it to you, Lords.
Yes, Mr. Mohanto. Lekha.
One thing,
So why this big file in this condition was lying here? Lekha. But Mr. We will say that you have admitted to that.
one thing, my lord,
Huh.
regularities of the handle.
Can't help it.
Criminal
Yes,
case
no,
is
my lord.
pending. Your
Criminal case I have opened for you.
Yes, that is true, but
That-
they open, that can be open for the, yes,
No,
Department
I'm
of
sorry.
Treasury, my lord.
After 4 years, if I interfere with the order, Darula's case, the show cause goes. Everything goes. But I will not put you back because now if I issue a fresh charge sheet, that will be beyond a period of 4 years. I'll not do that. Unfortunately, for the society at large, the loss has occasioned. Can't help it. Technically, I can't go. Lekho, as heard Mr. S. Bhattakur, learned counsel for the petitioner. Also heard Mr. D. Upamanyu, learned standing counsel, Higher Education Department, appearing for the respond number 1 and 2. Mr. P. Mohanto, learned counsel, appears for the respondent number 3, governing body, Bahana College. The petitioner in the present proceeding has presented a challenge to the order, to an order dated 30/11/2012 passed by the Director, Higher Education Assam, imposing upon the petitioner the penalty of dismissal from service with effect from 25/5/2010 on conclusion of a departmental proceeding instituted by him. What is the significance of 22/5/2010 date?
Twenty-two 5, your Lordship.
Very, very, 22/5, what is the significance? Okay, that is the date of your suspension.
Lordship. 22/5 suspended.
Then if you have dismissed it from retrospective effect, what happens to the proceeding? He is not there.
Lordship.
How did you conduct the proceedings then?
That was well with the approval of the government, whatever. is
No,
done.
you dismissed him retrospectively. Literally, he is not in service after 22/5/2010.
But that is.
So how did you hold the proceedings?
the approval by the director?
It seems to be a very
Ultimately, but
thing to get him out of the school.
the suspension period and everything was done with the director of the.
Okay, Lekha. With effect from so and so. The facts in brief requisite for adjudication of the issue rising in the present proceeding is noticed as under. The petitioner herein, while working as the in charge principal of Bahana College, comma, basing on certain allegations coming on record, allegations of commission of misconduct coming on record against him, comma, the governing body of the college proceeded to issue an order dated 25 proceeded to arrive at a decision in its meeting held on 19/5/2010 to place the petitioner under suspension for alleged involvement in a financial scandal in connection with utilization of funds of the college. So the said decision was placed before the Director of Higher Education Assam, who is the appointing authority of the petitioner, who otherwise, who is a provincialized, of the petitioner. Full stop. The director, wide order dated 25/2010, approved the said resolution dated 19/5/2010 of the governing body, and thereby the petitioner hearing, thereby the petitioner's suspension by the governing body of the college stood ratified. The order dated 25/2010 further proceeded to appoint the next senior most faculty as the principal in charge, come secretary of the governing body. Full stop. Thereafter, the governing body adopted a decision for appointing one Jagat Borthakur, retired additional DC, as the inquiry officer for drawal of departmental proceedings against the petitioner herein in its meeting held on 8/6/2010. Also, they said proposal on being placed before the Director of Higher Education Assam, approval was granted to the same, with a further stipulation that the whole process be completed within 30 days. Also, thereafter it is seen that a presenting officer, thereafter it is seen that the principal in charge of the college had wide a communication dated 14/8/2010, appointed one A. Das, a retired finance and accounts officer, as the financial expert in the said inquiry. Also, after the said developments had taken place, the inquiry officer, assuming the role of the disciplinary authority, proceeded to issue to the petitioner herein a show cause notice dated 15/2/2011, initiating against him a departmental proceeding. Also, the petitioner submitted his reply to the charges so framed against him in the show cause notice. Also, thereafter, it is seen that an inquiry was held in the matter. On conclusion of the inquiry officer submitted his report on 2/4/2012. Also, although the 2/4/2012, the inquiry report on being placed before the governing body of the college, you tell yes. Governing body in its meeting held on is the governing body resolution on record, Mr. Mountoff? Is it on record, Mr.
Lordship, page 27, your lordship.
of the reply?
Affidavit in opposition.
No, this is, the 27 is your defense assistant.
Okay. This, except these two, there are nothing, your lordship.
Okay. The governing body considered, they said inquiry report in its meeting. And recommended for
Held on 27/6/2000.
27/6/2020 and recommended for imposition of the penalty of dismissal from service upon the petitioner. So the matter was thereafter placed before the Director of Higher Education Assam for consideration. So, subpara, the Director of Higher Education Assam, on consideration of the matter, proceeded wide order dated 30/11/2012 to dismiss the petitioner herein from his services with effect from 22/5/2010 on the basis of the inquiry committee's report and the GB's resolution adopted therein. Also, the said order also reflects that the punishment penalty as imposed upon the petitioner had the approval of the government in the education bracket higher education higher bracket higher department. Being aggrieved, the petitioner has instituted the present proceedings. Mr. S. Bothakur, learned counsel for the petitioner, has submitted that the very initiation of the proceedings against the petitioner is vitiated inasmuch as the materials brought on record would reveal that even if it is admitted, if it is assumed that the governing body has the power to initiate a departmental proceeding against any of the employees in this college, the disciplinary proceeding initiated against the petitioner herein admittedly has not been initiated by the governing body, inasmuch as the show cause notice issued does not reflect any such decision taken by the governing body in the matter. He submits that the show cause notice having been issued by the inquiry officer on its own violation, the provisions of section 9 bracketed 2 of the Assam Discipline Service, Assam Services Discipline and Appeal bracket of it, rules 1964, read with rule 8 stood violated, and accordingly the very initiation of the proceedings stood vitiated. Accordingly, basing on such vitiated proceedings, no penalty was called upon to be imposed upon could have been imposed upon the petitioner herein. 2. Next, Mr. Bothakur submits that without prejudice to his submission, without prejudice to the submission made by him with regard to the maintainability of the proceedings, department proceedings instituted against him, he submits that the show cause notice issued having been so issued in clear violation of the provisions of Rule 21, of the Assam Services Pension Rules 1969, the proceedings cannot be held to be maintainable. Full stop. Mr. Bothakur submits that the petitioner had retired from his services on reaching submits that the petitioner was permitted to retire from his services on 30/9/2010 on reaching the age of superannuation. So it was after his such retirement that on 5/15/2011 that the impugned show cause notice came to be issued to him. Full stop. Mr. Bothakur submits that the proceedings, the proceedings now instituted against the petitioner having not been so instituted in terms of the provisions of Rule 21 of the Pension Rules 1969, the said penalty, that the proceeding would not be sustainable. Full stop. Mr. Bhattacharya, by referring to the order passed by the Director of Second Higher Education Assam, dated 30/11/2012, submits that the petitioner was imposed with a penalty of dismissal from service by invoking the provisions of Rule 7 of the Discipline and Appeal Rules, Assam Services Discipline and Appeal Rules 1964. He submits that the employee-employer relationship having ceased between the petitioner and the respondent authorities with effect from 30/9/2010, the petitioner could not have been imposed with a penalty under the Assam discipline and under the rules of 1964. The only permissible penalty that could have been imposed upon the petitioner is a curtailment on his pension to the extent as may be determined by the competent authority. Also, Mr. Bhattacharya submits that accordingly, even the penalty as imposed upon him being not in connivance with the provisions of law governing such required to govern such proceedings against a retired employee, who was not proceeded against during his service tenure, having not been complied, the penalty would mandate an interference. This much. Mr. Bhattacharya has further made his submission with regard to the merits of the matter. However, the same would be adverted to at a later stage in this decision, in this judgment, if the occasion so necessitates. Full stop. Per contra, Mr. E. Upamanyu, Learned Counsel for the Learned Standing Council, Higher Education Department, has submitted that after the coming into force of the there is a problem. Every other rule here, I get it in a touch somehow, but I have never got these college rules at one touch. Never. 10 rules and the 5 Act. Never I have got it. I every day miss this 490. And this is not here, that side also, same thing. 490, huh? Force of the Assam College Employees Provincialization Act 2005 and the rules thereunder of 2010. The appointing authority being the Director of Higher Education Assam, the disciplinary authority of a provincialized college employee would also be the Director of Higher Education Assam. Also, he, however, submits that in the present case, it is seen that exercising the residual power under Rule 27 of the Rules of 2010, the governing body was directed by the then Director Higher Education Assam to initiate proceedings against the petitioner herein. He fairly submits that the petitioner was not subjected to a disciplinary proceeding during his service tenure, and the disciplinary proceedings stood instituted against him on 15/2/2011 with the issuance of the show cause notice in question. That is, after the petitioner had proceeded on retirement on reaching the age of superannuation with effect from 30/9/2010. He has also fairly submitted that the penalty as imposed upon him by the order dated 30/11/2012 may not be sustainable inasmuch as the same was so invoking the provisions of Rule 7 of the rules of 1964, which may perhaps not be permissible to be invoked after the proceedings involved in respect of an employee against whom disciplinary proceedings stood initiated after the date after he had proceeded on retirement on reaching the age of superannuation. Having made the above submissions, Mr. Having made the above submissions, Mr. D. Upamanyu submits that the allegations leveled against the petitioner is very serious in nature, and the same has the effect of, and the same pertaining to the mismanagement and pertaining to misappropriation of college funds of the college during his tenure as the principal in charge thereof, this court would permit the respondent authorities to initiate a fresh proceeding against the petitioner strictly in accordance with law. Mr. P. Mohanto, learned counsel, appearing for the respondent number 3, that is the governing body, Bahona College, adopting the arguments of Mr. D. Upamanyu, submits that the governing body had acted in the matter quickly in terms of the directions issued to it by the Director of Higher Education, Assam. Mr. Mohanto submits that the college authorities, not having the expertise to frame charges as required to be so framed under the mandate of the provisions of Rule 9, the college authorities had appointed one Jagat Borthakur for the purpose of framing of the charges. Also, he submits that although the show cause notice was not found to have been issued by the governing body of the college to the petitioner herein, he, by referring to the charge memo as annexed to the communication dated 28/4/2011. No. So cause this at 15/2/2011 submits that the signature of the president of the governing body is available therein, which reflects that the show cause notice was issued by the governing body and not per se by the inquiry officer. He submits that on conclusion of the inquiry, the charges against the petitioner having been found to be established, the same was considered by the GB and a major penalty was proposed to be imposed upon the petitioner, and thereafter the matter was referred to the Director, Higher Education, for passing of appropriate orders in the matter. So he submits that the director had thereafter passed the order dated 30/11/2012, imposing the penalty of dismissal with retrospective effect upon the petitioner herein. Mr. Mohanto submits that the charges leveled against the petitioner submits that a mere perusal of the charges leveled against the said petitioner would bring to the forefront the extent of misappropriation committed by him during the period he had held the charge of the principal of the college. He submits that the amount misappropriated by the petitioner being public money, the same must under all circumstances be recovered. Accordingly, he reiterates that the respondent authorities be permitted to Accordingly, he submits that in the event this court is pleased to interfere with the proceedings instituted against the petitioner, comma, which again would be on a technicality, comma, prays that the respondent authorities be permitted to institute fresh proceedings against the petitioner herein. Well, I've heard the learned counsel for the parties and also perused the material available on record. As agreed to by the learned counsel for the parties, this court at the outset would consider the preliminary issues raised with regard to the very maintainability of the proceedings instituted against the petitioner herein. The learned counsel for the petitioner at the outset had contended that the show cause notice issued to the show cause notice dated 15/2/2011, having been issued to the petitioner by the inquiry officer, the same would not be maintainable. So, this court has perused the show cause notice dated 15/2/2011 and finds that the same was issued by the inquiry officer by assuming the powers of a disciplinary authority. The show cause notice dated 15/2/2011 does not reveal that the same was being so issued by the inquiry officer as authorized by the disciplinary authority, which in the present case may either be the governing body or the Director of Higher Education, Assam. Another interesting factor which has come to the notice of this court is that the inquiry officer, while issuing the said show cause notice dated 15/2/2011, had required the petitioner to submit his show cause reply to him. Also, and further had required the petitioner to communicate with him in the event the petitioner desires to inspect the documents. The said powers are reserved for the disciplinary authority under the provisions of the Assam Services Discipline and Appeal Rules. Also, Section 9(2) of the said rules of 1964 mandate that the disciplinary authority is to frame definite charges on the basis of the allegation on which the inquiry is proposed to be held. The rules, these rules further provide that the charges on being framed, comma, together with the statement of allegation on which they are based, comma, is required to be communicated in writing to the delinquent, who shall thereafter submit to the disciplinary authority within the time frame prescribed a written statement in his defense. The term disciplinary authority, as finding mention in the provisions of Subrule 2 of Rule 9 of the Rules of 1964, is defined in the provisions of Rule 8 of the said Rules of 1964 to mean an appointing authority or by any other authority empowered, to mean an appointing authority or any other authority empowered for the purpose by a general or special order of the governor. The above being the position, comma, this court would examine as to who would be the disciplinary authority of the petitioner. Also, the petitioner herein is a provincialized employee, and accordingly, he is covered by the provisions of the 40, what was that? Yeah, this is real problematic for me. 490. There is some dushmani with this act with me. Enmity. Covered by the provisions of the Assam College Employees Bracket Provincialization Act 2005. Also, the provisions of the said act on a perusal would reveal that the appointment of both teaching and non-teaching staff in a college is to be made by the Director of Higher Education Assam. Also, the petitioner hearing was admittedly a teaching staff, although he was holding the post of principal. However, although he was functioning as the principal of the college, which was only on an ad hoc basis. Accordingly, it can be held that the disciplinary authority of the petitioner is the Director of Higher Education, being the appointing authority. However, on a perusal of the provisions of the Assam College Employees Bracket Provincialization Bracket over Rules 2010, which, while extending the provisions of the rules of 1964 to all the employees covered by the provisions of the Act of 2005, has in Rule 27 reserved the residual power of an appointing authority upon the governing body of a college. It stipulates that the governing body of the college shall exercise all other powers of the appointing authority as per usual norms. A perusal of the provisions of the Act of 2005 as well as that of the rules of 2010 brings to the forefront that the director, that the rulemaking authority had, that the competent authority had only reserved the right of appointment to the Director, Higher Education. However, he, being the appointing authority, would also be empowered, would also, under the provisions of Article 311, be the authority only empowered to impose upon a member covered by the provisions of the Act of 2005 and the rules of 2010 a penalty of removal, dismissal, removal, or compulsory retirement. However, the set position would be different for the purpose of initiating an inquiry. The powers, the governing body under Rule 27 of the rules of 2010 having been conferred with the residual powers of the appointing authority, in absence of any other material brought on record, insofar as the present writ petition is concerned, this court concludes that the governing body of the college had the power and had the jurisdiction, was within its jurisdiction to initiate a departmental proceeding against the petitioner, which is found to have been so initiated after the same was approved by the Director of Higher Education Assam. Having drawn the above conclusion, this court finds that the governing body of the college had abdicated its functions, and the initiation of having drawn the above conclusions and noticing and presuming the governing body as the disciplinary authority of the petitioner herein under the provisions of Rule 2, Sub-Rule 2 of Rule 9, read with Rule 8 of the rules of 1964. This court finds that the governing body of the college had abdicated its function, and it was the initiation of departmental proceedings against the petitioner was by the inquiry officer. So, there being no material brought on record that such initiation by the inquiry officer of a departmental proceeding against the petitioner was after a due approval for this purpose was granted along with approval of the charges so framed against the petitioner, while the show cause notice dated 5/12 KSL, dated so and so, this court holds that the issuance of the inquiry by issuance of the show cause notice by the inquiry officer that shows that holds that the issuance of the show cause notice by the inquiry officer initiating a departmental proceeding against the petitioner was in violation of the provisions of the rules of 1964. It is a settled position that despite the provisions of Article 311, which mandates that it is only the appointing authority who can impose upon a delinquent the penalty of dismissal, removal, and compulsory retirement, a rule under 309 having been framed, and therein a specific provision having been made requiring a specific provision having been made, specifying the authority to initiate the departmental proceeding against a member covered by the rules of 1964. This court is of the considered view that no authority other than the specified authority, that is the disciplinary authority, could initiate such proceedings. So, this court, in support of its set conclusions, relies upon the decision of the Honorable Supreme Court in the case of Union of India and others versus B.V. Gopinath, reported in 2014 1 SSC 351. So, the Honorable Supreme Court in the said decision had drawn the following conclusion. Para 41 to my. This court also relies on the decision of the Honorable Supreme Court in the case of State of Tamil Nadu, represented by Secretary to the Government, bracketed home, versus Pramod Kumar, IPS, and another, reported in 2018 17 SSC 677. Wherein the principles laid down in the case of B.V. Gopinath Supra was reiterated. Full stop. The Honorable Supreme Court in the said case had drawn the following conclusion. Para 23. Para 21 onwards. 21, 22, 23. So, applying the decisions of the Honorable Supreme Court in the cases of so and so to the facts of the present case, this court can safely conclude that the disciplinary proceeding instituted against the petitioner was so instituted in clear violation of the provisions of the rules of 1964, inasmuch as the show cause notice / charge memo was not issued by the disciplinary authority and was issued by an authority not envisaged in the provisions of the rules. Having drawn the above conclusion, this court would now examine the second preliminary objection raised by Mr. Bhattacharya as Bhattacharya, learned counsel for the petition, the effect that the disciplinary, the petitioner having superannuated from his services on 30/9/2010, the show cause notice issued thereafter on 15/2/2011 would not have been so issued, ignoring the provisions of Rule 21 of the Assam Services Pension Rules 1969. Also, the set the facts, it is an admitted position that the petitioner herein had retired from his services on 30/9/2010, and it is only thereafter that the disciplinary proceeding against him was so instituted, wide issuance of the show cause notice on 15. Also, the disciplinary authority could not have instituted the proceedings against the petitioner under the provisions of the rules of 1964, and such proceedings was mandated to be so instituted under the provisions of Section 21 of the rules of 1961. Although the procedure under the provisions of Rule 9 of the rules of 1962 would have to be followed even in proceedings under Section 21. Having noticed the above position and finding that the rules of 1960, Rule 21 of 1969, rules of 1969 was not complied with, this court is of the view that the show cause notice dated so and so would not be maintainable and would call for an interference. Also, at this stage, this court would peruse, would notice the order dated 30/11/2012 passed by the Director of Higher Education Assam on the matter being placed before him after conclusion of the inquiry held in the matter against the petitioner. The said order being relevant is extracted here in below, A to A. Page 259. A perusal of the said order would reveal that the petitioner herein was imposed with a penalty of dismissal from service with effect from 22/5/2010 by invoking the provisions of Para 7 of the Assam Civil Service. This is a new rule. Assam Service Discipline and Appeal Rules 1964. As noticed herein above, the petitioner had retired from his services on reaching the age of superannuation with effect from 30/9/2010. After 30/9/2010, the employer relationship between the petitioner and the respondents ceased. The petitioner herein not being a government servant after 30/9/2010, he could not have been imposed with a penalty under the provisions of the rules of 1964. The only penalty permissible to be imposed upon the petitioner was that contemplated under the provisions of Section 21 of the rules of 1969. So, admittedly, the penalty imposed upon the petitioner being one not contemplated, not mandated to be imposed upon him in the facts and circumstances of this case, this court is of the considered view that the order dated so and so would also mandate an interference. So, having drawn the above conclusion, this court would now examine. This court having drawn the above conclusions drawn by this court having the effect of an interference being made by this court with the proceedings instituted against the petitioner, including the penalty so imposed up, This court would now consider the submissions made by the learned counsel for the respondents for a grant of permission to institute a fresh proceeding in the matter against the petitioner. They said contention is being considered only to be rejected. The allegations forming the basis of the show cause notice issued against the petitioner pertains to a period prior to 2011 and even relates back to what is the earliest period, Mr. But two periods to relates back to a period of 2005-2006. This court having the full stop. The penalty in the matter was imposed upon the petitioner in the year 2012. 13 years at least with effect from the date of imposition of the petitioner. Penalty upon the petitioner has lapsed and the petitioner is found to have been litigating in the matter since then before this court. The respondent authorities were very callous in their approach in the matter while instituting proceedings against the petitioner. While the petitioner is guilty of a misconduct, the manner in which the proceedings have been instituted against the petitioner reveals that the authorities empowered to discipline him were also guilty of properly conducting the proceedings, which has the effect of exonerating the petitioner. The authorities involved having either passed away, it is stated in the bar that the authorities involved in conduct of the proceedings against the petitioner have either passed away and or have already retired from their services. Accordingly, this court does not intend to proceed any further, to make any further comment in this connection, but to only observe that the state, while dealing with an allegation of misconduct against a person, and such allegation involves misappropriation, involves a breach of trust, leading to misappropriation of a huge amount of public money, the state authorities ought to be very careful while proceeding at each stage of such proceeding. So, in view of the above discussion, this court in view of the above discussion and the conclusions drawn, this court, the show cause notice dated 15/2/2011 stands set aside along with all proceedings proceedings conducted thereafter, including the inquiry report. This court also set aside the order dated 30/11/2012 passed by the Director of Higher Education Assam imposing the penalty of dismissal from service upon the petitioner. So, the impugned orders have been set aside. The petitioner is directed to be authorized his due pay, and having been set aside, the period of suspension of the petitioner is directed to be regularized as on duty with release of his due salaries to him. So, thereafter, the respondent authorities shall promptly process the pension and pensionary benefit proposal for pension and release of pension and pensionary benefits to the petitioner, and ensure that the same is received by the petitioner within an outer limit of 6 months from the date of receipt of a certified copy. Also, however, the areas of pay and allowances receivable by the petitioner, along with a provisional pension since the date of his superannuation, shall be released authorized to the petitioner within a period of 3 months from the date of receipt of a certified copy. With the above observations and directions, the writ petition stands disposed of. You told 15 minutes. It took me.
Safely on.
One did 4 months. 4 months, Koide.
Safely applied.
Anything more?
Probably there is a mistake.
No, he says he's provincial.
Getting
He's
safely on.
now you conceded. Otherwise, I would have gone a step further. Can't help it. He's gone. Catch him in the disciplinary, in the criminal case.
Criminal case.
That I have already. So it's 50-50 for you. There was a quashing proceeding.
Passing.
That I did not allow. Yeah.
Lord,
Yes, Mr. Raga. You have filed your affidavit also.
my lord, I have seen that both the affidavit pillar.
Okay.
On that day, I did not see it. So I want to file an additional affidavit for myself too.
Shall we,
But
we
I
can
have
consider
that
it for
there is no-
disposal then?
My lord,
We can consider it for disposal. Make your submissions. Yes, where is your? Who? There is no other person available. Tomorrow. Tuesday by any board is মই নাথাকো কোনোবা বেলেগৰ গালি নিদিব
my lord, the matter
এটা ফিক্স কৰি থৈ হা আগো বুঝবো
had many times. This was, I feel that the petitioners
Okay.
My lord,
Okay. We can't help it. 2015 matter, a senior person is making a mention, we'll hear him. Yes.
my lord, the matter is only depends on 2 points. Petitioners were appointed as Sahayok
Itu
in
Maharani, oh,
2007. His service was not regularized for
Okay, petitioner was appointed.
as Sahayok. This is the petitioner service as a casual Sahayok since 7/4/2007 in the office of the Chief Executive Officer, Nagaon Electrical Circle, Nagaon, which is within one of the branch office of Assam Power Distribution Company, my lord.
So he is
After
working
15
from
years,
when?
my lord.
When is the date? 4/7/2007.
Yes, my lord. Many years after, in the period his service was not regularized, but the authority decided to fill up some post of Sahayok, 66 Sahayok, my lord. And the application were called for. And there are 2 kinds of candidates, one departmental candidate, another is one private. Private means the ITA pass. The ITA's candidate needs to be provided by the concerned employment exchange, and departmental candidates were prepared from their office.
Hmm.
In the list, in the list of candidates, my lord, final list of the candidates, the name of the respondent number 5
Hmm.
was not there. And examination was held. After examination, at the time of examination,
Hmm.
interview, the roll number of the petitioner was D083. But when results come out,
Oh,
This number
not a department. What is the petitioner's roll number?
D083, D means departmental, my lord.
Okay.
And another was the respondent number 5. His roll number was 083. They have shown, but he is not a candidate.
He is
Like-
083.
Yes, but the petitioner has claimed that he was not a candidate. And the respondent authorities have not been able to prove that he was a candidate. But they are telling that his roll number was tampered by the petitioner. In this connection, I would like to go on, my lord. The respondent authority director, the executive engineer, made an inquiry. Inquiry report is
Enquiry made by
made by some officers, my lord.
officers of the
Officer of their
respondent.
own office, not from us with that. They have this made an allegation. that-
APDCL,
Lord,
APDCL.
yes, judicial. Yes, that Nago is a branch office.
Okay. Where is that enquiry
Yes, my
report?
lord. He has been called for interview. I might, the matter is that inquiry report was not given to him till the date of hearing on motion of this case. On the date of motion, they told that there was an inquiry, and in inquiry report also they alleged that the number D word D against the result sheet was tampered by him. So in this connection, the result result could be maybe may be similar at serial 21 of the petition, and also 22 and 23. In 23,
Now, what is the select list at 21?
my lord,
Select list at 21, what is this?
the select list against this roll number, the name of one Amuli, roll number 5 is shown as 0
Now, where in page 20?
083, my lord.
Mr. Dekar, where do I get it in page number 21? What is page number 21?
Page number 21, my lord, results is B, Annexure B.
Result sheet. Then,
Annexure B. The matter is that, my lord,
but here your name is not there.
my lord,
Page 21, your name is not there.
no, 21 is, 20 is a, my lord, there are two lists, one on 20.
How can there be two lists?
One is waiting list, one is waiting.
Where is that waiting list?
Waiting the mind of C, Annexure C. Annexure C.
This is waiting.
Yes, 23.
And in the waiting list, the name of the respond number 5 with your roll number figures.
0D, 083. This number was of the petitioner. This number is tampered. It is told, it is stated by the respondent authority. But this is the original sheet, my lord. Signed by the officer.
Where?
Yeah. But they are now telling that.
Page 23.
Yes, my lord. 23,
But the other signatures of the other members are not there.
my lord.
Okay. Then what happened?
But they are telling that all the records, this honorable court directed the respondent authority to file all records regarding examination, regarding test, and all other results is etc. But they have submitted their statement that the records are missing. They could not file the records, and they have some now in the yes, my lord, additional affidavit. They are most important.
That new 11-2
Additional affidavit.
Hmm.
Two. There are two.
Yes.
That the deponent respectfully states that every possible effort was made to obtain the original records. However, despite such efforts, the original records could not be traced by the APDCL. The deponent respectfully states that on an earlier occasion, an inquiry committee had been constituted as per the approval of the managing director, APDCL, filed an office order dated 16/3/22. The said committee consisted of the general manager, HR, APDCL, the assistant general manager, the deputy manager, HR, APDCL, the assistant general manager, law, etc., and the assistant manager law. The said committee visited the office of the chief executive officer, Nago Electrical Circle, on 22/3/22. During this said visit, the original records were thoroughly searched, but the same could not be traced. The committee thereafter submitted a report dated 29/3/E. Copy my annexure.
That is at page 12.
Yes. My lord, there is an examination in every district, in many districts, many subdivision,
Hmm.
but entire records is missing. Entire record is missing, and they have then the para 4 of this report, my lord, para 4, that the deponent most respectfully states that the judicial authorities, however, were able to reach out to the respondent number 5, seeking relevant records of the recruitment process. Respondent number 5 accordingly visited the registered office of the APDCL located at Guwahati on 18/1/25. The respondent number 5 thereafter furnished original copies of the following documents: calling letter by which he was called for interview, calling letter dated Iman 2, and appointment letter Iman of the respondent, my lord. The number 5, page 5, para 5, that the respondent humbly submits that the case projected by the petitioner is that the respondent number 5 was selected against the roll number D83, which was the exact same roll number assigned to the petitioner.
Yes.
The petitioner claims that he was not a candidate. In the original list of candidates, they could not show his name.
Where is that original list of?
Yes, my lord.
Is it annexed to the writ petition? Is it annexed to the writ petition?
Yeah, here is annexed the photostat, right? But this is original.
No, where is the photostat?
Hello?
Photostat copy? It is
Enclosed
there on record?
in my repetition, my lord.
Okay.
Here's my lord 25. 25. Here is name of the petitioner is at serial 109.
109. Jivon Chandra Bora.
Yes, my lord. Jivasur Brown. As a departmental career already clearly stated herein,
Hmm.
time of prediction, he has 1 year experience in the same office, and total category 60 number was approved. Pilot was approved. He was working, that was approved by the executive office. So he was a departmental candidate, having 1 year experience at the time of his application. But in this list, my lord, there is no name of the petitioner 5. In the affidavit filed by the responsible authority,
Annexure C.
yes, right, in the affidavit, first affidavit, page 16 of the affidavit. Respondent
Serial number
Ranjit
88.
Kumar is shown
Serial number 88.
88. But the copy they have also submitted.
Okay.
This copy-
Now, Mr. Teka,
Right.
how do you vouch for the copy which you have annexed? What is the authenticity of this copy?
So,
It's just a type copy. What is the authenticity of this copy?
No, we have authenticity, but they have submitted this.
No, no, how have you got this?
My lord, they are, under RTI,
Where is that RTI forwarding
my
application?
lord. There are several numbers of RTI application, my lord.
No, no, I want the RTI covering letter for this because this does not bear the signature of the authority. No authority signature is here.
So, yes, in origin, there is signature, my lord.
No, no, here in this page.
There is signature.
No, no, here you don't say. There I don't find page 25 onwards, I don't find any signature.
55.
It is just a typed out copy.
So origin, there is origin, my lord. Origin means there is signature stamp.
How did you get it?
They are, collected by RTI, my lord.
RTI, where is that RTI?
Where RTI application, at page.
Where is that
50,
RTI?
the application, my lord.
Huh? 55.
Yes, my lord.
This is subsequent.
One is 55,
Huh.
another is at page 57.
Hmm.
Another one at 28.
So where is the reply to
And
this?
lastly, my lord, one report, they have submitted reply, my lord. Reply.
RTI, huh?
Yes,
They have
page
clarified here.
60.
Hmm.
Page 60 may kindly be
Yes.
see, my lord.
Hmm.
Here, the last para. In the select list, instead of printing roll number D, 083 ITI, touch the name of Sri Ranjit Kumar Tamuli, roll number 083, was wrongly inserted at serial number 2636.
Okay.
Next are B due to typing error, my lord, of our side.
Okay.
But in the affidavit,
They say that you have done it.
affidavit, my lord,
They say you have done it.
yes, I have done. In the affidavit. But in the
Okay.
affidavit, this point has been leading. This does not come.
They have not touched that
Yes,
point.
my lord. In the first, this is not. Only they are searching the records, and records are not able anywhere.
Anything more, Mr.
There is order of this honorable court also, my lord, to submit the records.
That
You know,
they have given.
But
I passed that order.
Entire matter, my lord, is misleading.
Okay. Anything more?
Lord, the petitioner's claim is genuine. The respondent authority have no any record to show that
Now, how do I draw the satisfaction that it is you and not the petitioner? Because this is also not authenticated. There is nothing here.
yes, Mr.
That page 23.
23. Is my lord result. Has the
No, no, where is the original of this?
yes, my lord, signed by the officer, my lord.
No, no, where is the original of this? How did you get it? How did you get it?
I got it by RTI.
When?
I applied for RTI, and it was handed over to me on my lord. If that is not here because they have handed over me.
No, no. How do they hand it over without a forwarding letter? There has to be a letter somewhere.
No, my lord, I was not given hand letter.
No, no. Where have you stated that you have received it under RTI in your writ petition?
I have written. I look at
Where have you written?
against enclosure, against enclosure, my lord. 23. Against 23.
Where? Where is the provision that this select list? Rather, you have questioned the select list. Mr. Deka, you have questioned the select list in para 9. If you can just come over to para 9 of your writ petition, paragraph 9.
The petitioner was respectfully further states that the result of the aforesaid physical test and interview was published on 15/10/2014. That is, more than 5 years elapsed from the date of aforesaid physical test. An interview were held and select list published on 15/11/14. He has signed only by the Assistant General Manager. Has been signed only by the Assistant General Manager, HR, and there appears no signature of other members of the selection committee, interview board, which might indicate the lack of fair play in finalizing the above select list. That serial, my lord.
So this copy, these two annexures,
Ah.
B and C, you are disputing yourself.
No, my lord.
Yes, you have disputed that this is prepared without any lack of fair play. And
No, I am not saying that only one officer.
so that list we cannot rely upon. B and C, we will not rely upon.
In the result sheet, my lord.
Which one? B and C only.
Result sheet.
B and C, you have questioned yourself, Mr. Deka. You have questioned yourself in para 9, saying that this is not fair. This is only as the signature of Assistant General Manager, nobody else. So how can we? So
Not
we
fair.
we will not take cognizance of B and C. Because both these lists are bogus. So what is left is the only an inquiry report of the authorities. Disputed questions having come into face, how can we help you? We can't help you.
My lord, I have collected the copy.
I got it, but your statement is
What
contrary.
they have taken,
Mr. Deka, please try to understand your statement is contrary to what you are trying to project. Para 9.
has been signed in original my what I have received in that result sheet.
That is what you
Yes,
have,
signature.
that is what you have annexed as annexure B and C. Nothing else. So that you yourself, when you are questioning it, how can we place reliance on that? We can't. Sorry. Very difficult. Next time, better case.
My lord.
Next time, better case. But Mr. Yes.
That's like I'll be sitting on Monday.
No. We have heard. You wanted it. I heard it. I even wanted not to hear them. I was about to grant. Now no adjournment, Mr. Deka. Heard Mr. C. Deka, Learned Counsel for the petitioner. Also heard Mr. W. Ahmed appearing for Mr. B. Chaudhary, Learned Standing Counsel, APDCL. Appearing for B. Chaudhary, Standing Counsel, APDCL for the respondents. The petitioner in the present proceeding, Mr. Please have a seat. Please have a seat. The petitioner, by way of instituting the present proceeding, has presented a challenge to the selection and appointment of the respondent number 5 herein to the post of Sahayak by a Sahayak in pursuance to a selection held in the matter. Post of, as projected in the writ petition, next para. The petitioner herein was working as a contractual, as a casual Sahayak in the establishment of the respondent number 3. That is the Deputy General Manager, Nagaon Electrical Circle, CAZ Assam Power, CAZ oblique, CAZ, APDCL. So, since 0407/2007, the services of the petitioner not being regularized. The petitioner also projects that after having worked for around 7 years, 8 months, his services were not regularized, and he continued to discharge his duties as a casual Sahayak. So, at this stage, the respondent authorities, the APDCL authorities, issued a communication dated 24/8/2009, inviting applications. No. The APDCL authorities at this stage initiated a process for selection against the post of Sahayak, and for the purpose, both the casual Sahayaks and persons having the ITI qualifications were made eligible for participation therein. The petitioner, being a casual Sahayak, forwarded his candidature for recruitment against the post of Sahayak. Full stop. Accordingly, the petitioner was issued with a calling letter dated 24/8/2009. In the said calling letter, the petitioner's roll number for the selection was denoted as D'(D-083). D stands for departmental candidate. Likewise, the petitioner further projects that the respondent number 5 herein had not submitted his candidature for the selection process. However, when the final select list was so published, the name of the respondent number 5 was found at serial number 36 of the waiting list. However, the roll number shown therein was that of the petitioner. So the petitioner projects that after receiving the requisite instructions, he had instituted the present proceeding. Also, Mr. C. Decca, after reiterating the facts noticed herein above, has submitted that the roll number that in the waiting list annexed as Annexure C to the present writ petition, at serial number 36, the name of the respondent number 5 figures. However, his roll number has been denoted as D'083, which in fact is the real number of the petitioner herein. He submits that the same would reveal that it was the petitioner who was selected, and he was substituted by the respondent authorities. He was substituted by the respondent number 5 by authorities favorable, by the authorities of APDCL favorable to the respondent number 5. He submits that the original records of the matter, although directed to be produced by this court, have been projected by the APDCL authorities to be missing. Also, Mr. Decca has further referred to an RTI reply received by him on 26/2/15, wherein it was noted by the authorities of APDCL that the actual roll number of the respondent number 5 is 083 bracketed ITI, and that of the petitioner herein is D-083 bracket DEPTT bracket over. However, in the select list, the name of the respondent number 5 against the name of the respondent number 5, roll number D'083 was wrongly inserted instead of 083. He submits that while filing the affidavit in opposition, the respondents have taken a different plea and therein have contended that the prefix D against the roll number of the respondent number 5 was inserted by the petitioner. Mr. Decca accordingly submits that the respondents have been taken different stands in the matter at different stages of the proceeding. Accordingly, he submits that the roll number of the petitioner figuring in the select list comma, he must be construed to be the one selected for the appointment, and accordingly, this court would called upon to interfere with the appointment in respect of the respondent number 5 with consequential direction to the APDCL authorities to appoint the petitioner against the post of Sahayak with all retrospectively with all consequences. That's your case, Mr. Deca. That is your case.
My lord, he has not the respondent number 5
I have said that.
approved case, my lord.
I have said that. I have said that.
Registrar cannot be
Mr. Deca has further submitted that the respondent number 5 was never a candidate in the selection process, and he was incorporated in the select list by certain authorities in the organization favorable to him to the prejudice of the petitioner. Well, issue, can you this much? By contrast, the learned counsel appearing for the respondents has submitted that the name of the petitioner was that the respondent number 5 had submitted his candidature for the selection process, and his name is duly entered in the register of ITI pass candidates. So, on his such application, the respondent number 5 was allotted roll number 83. Also, on conclusion of the selection process, it is submitted that the select list prepared, which has been indicated to have been brought on record in the affidavit, reflects that the petitioner, that the respondent number 5 was placed at serial number 36 of the waiting list, and therein, against his name, roll number was recorded as 083. The learned counsel for the respondent has further submitted that in pursuance to directions passed by this court for production of the original records, a search was made, and it was revealed that earlier an inquiry was also held in the matter, and a copy of the inquiry report was brought on record by way of filing an additional affidavit. The learned counsel for the respondent submits that the perusal of the inquiry report dated 29/3/2022 would reveal that the respondent number 5 was a candidate for the selection involved, and on his selection, he was appointed against the post of Sahayak. It is further projected that the respondent number 5 has since also been promoted to the next higher post. The learned counsel for the respondents in the above backdrop has submitted that the petitioner has not been able to effectively demonstrate that he was in any manner, that any prejudice was caused to the petitioner. It is submitted that the prefix, that the select list as annexed by the petitioner was so annexed by him by getting his signature on the said select list by incorporating the prefix D to the roll number of the respondent number 6. Also, accordingly, it is submitted by the learned counsel for the respondents that the claim of the petitioner herein would not mandate any interference. I've heard the learned counsel for the respondents. The rival contentions made by the petition parties to the proceedings bring to on record a disputed position with regard to the facts involved. However, basing on the materials on record, this court has endeavored to consider the grievance of the petitioner herein. The basis for the case of the petitioner is a select list brought on record, select list dated 15/11/2014, brought on record of the present proceeding and as annexures A, B, and C respectively. A perusal of the said select list annexed as annexure B and C would reveal that the same has the signature of one of the Assistant General Manager bracketed HR, Nagaon Electrical Circle, APDCL bracket CAZ, Nagaon, Assam. In the waiting list as brought on record wide Annexure C, at serial number 36 thereof, the name of the respondent number 5 figures. However, the roll number assigned to him therein is apostrophe D-083. Ali, huh? So, the respondent number 5 admittedly is not a departmental candidate and cannot be assigned a roll number with the prefix D. The respondent number 35 is a ITI pass candidate. So, what is interesting here is that while the petitioner has placed reliance on the select list at Annexure B and C, in paragraph 9 of the writ petition, he has questioned the very select list. The pleadings brought on, the contentions raised by the petitioner in para 9 being relevant is extracted here in below. Para 9, page 8, A to A. A perusal of the said contentions would reveal that the petitioner has questioned the preparation of the said select list. Accordingly, the petitioner cannot be this court cannot envisage a situation wherein after questioning the select list in question, the petitioner is also trying to take advantage thereof. Having drawn the above conclusions, this court would now examine the contention raised by the learned counsel for the petitioner that the respondent number 5 was not had not submitted his candidature in pursuance to the advertisement issued in the matter for recruitment to the post of Saha, and in this connection has relied upon the list of candidates participating in the selection process and brought on record as Annexure E to the writ petition. A perusal of the Annexure D would reveal that the same is a type copy and there is no disclosure made in the writ petition as to the manner in which the petitioner has received the said list. Accordingly, this court is of the considered view that no credence can be given to said list. Having noticed the said position, this court finds that the respondents in their affidavit have brought on record a list of candidates appearing ITI pass candidates who had submitted their candidature in pursuance to the advertisement in question, and therein the name of the petition respondent number 5 figures at serial number 88. They said same being an official document, this court cannot ignore the same, more so when the same has not been demonstrated to have not been produced from the records of the respondents. Also, having drawn the above conclusions, this court further finds that the respondent number 5, that the respondents have also brought on record to an additional affidavit the call letter issued to the respondent number 5. A perusal of the call letter issued to the respondent number 5 reveals that he was assigned the roll number 083 in the selection process. Also, the respondents have also annexed a select list along with their affidavit, and therein it is seen that the same, insofar as signature of the authorities figuring therein differs from the one produced by the petitioner herein. In the set select list, more particularly in the waiting list thereof, at serial number 36, the name of the petitioner. Respondent number 5 figures. However, the roll number assigned to him in the present select list is 083. Also, this court has also considered an inquiry report dated 29/3/2022 relied upon by the respondents in their additional affidavit, wherein again, after noticing the facts noticed by this court herein above, it was reiterated that that it was the respondent number 5 with a roll number 083 who was selected for appointment against the post of Ahayek, and the petitioner herein was not a selected candidate for the said post. In view of the above discussion as well as the disputed questions of facts coming in on record, this court refrains from interfering with the selection and appointment of the respondent number 5 as Sahayek. Also, further, this court also finds that the petitioner herein had failed to establish his claim that he was a selected candidate, and accordingly, this court is not in a position to extend any benefit to the petitioner herein as claimed in the present writ petition. Also, in view of the above discussion, this court is of the considered view that the present writ petition is devoid of any merit, and accordingly, the same stands dismissed. However, there would be no order as to cause. I'm sorry, Mr. Begum. Yes, Mr. Das.
Petitioner son was, my lord, sectional assistant. He worked, my lord, 37/1992, my lord, 12/2000. Died in harness, my lord. So mother prayed for family pension.
Show me the law.
Earlier occasion, my lord, file on the petition was put, my lord, withdrawn because we challenged the pension provision, my lord.
Mother is eligible.
Eligible.
No doubt about it.
Yeah.
Now tell me, without your father's but the husband's service being regularized, how can I give you pension?
No, my lord, it is son was not regularized, but he worked, my lord, up to, my lord, and
Show me the provision to regularize his service. Without regularizing, he will not become a government servant.
but process was there before 1/4/93. He was there.
Show me that somewhere his name was approved. Somewhere. Rest I'll take care.
Yes, my lord. Page 27. Reference to the above, it appears from the again.
Oh, this is from the additional that just a letter.
Yes, my lord.
Where is the approval given that to regularize your services?
But these are the names, my lord, left out. That is mentioned, my lord.
That is
Page
mentioned,
28.
we also accept.
Yes, my lord.
What is your husband's name?
Husband, not
My son's name?
my lord, Amol Medhi. Amol Kumar Medhi.
When did he die?
Died, my lord, on, my lord, I have
2000.
notes here. Last page 32. The office and staff of the office of the date. So 5/12/2000.
2000. Now, if this grievance is there from 93, what was he doing for 7 years? Not married.
Not married. My lord,
What is the age of the mother?
at the time of filing, my lord.
15, 10, 70. Can't help it.
Earlier occasion also we filed case, my lord, and challenged the But here they have mentioned specific, I have challenged the last letter, my lord, last page, governor order.
What is that order? Page?
Findings, the petitioner's son Amal Kumar Medhi was engaged workers.
Rightly so. Show me what is the error there.
Second portion, my lord, it is mentioned that she is not entitled, because here it is mentioned that mother of the deceased Amal Kumar Medhi is not entitled to pension as
That is gone. That we will clarify. That much will do.
subsequently, my lord, no, subsequently, my lord, they have, my lord,
Amended.
that amendment has been annexed by.
There are two parts. The
Part,
second part will go,
Yes, my
but
lord.
the first part will remain.
So, my lord, she needs, my lord, as it was a old one case, my lord, and my lord, from the last, admittedly, her son worked there, my lord, from my lord
Tell me
37.
what is my power to regularize his services retrospectively?
I am not praying for regulation.
You're
my
not
lord.
praying for regulation.
Regulation,
Then
only to get, my lord, family
tell me
pension.
how you will get it without regularization. Show me the law.
No, I have, earlier, my lord, there are numbers of judgment because.
Numbers, you give me one.
Amendment of the husband. Employer-employee relationship. That's benefit, my lord.
Therefore, respondent widow not entitled to family pension. This will go against you. Hussain Ali is on a different facts altogether.
Yes, my lord. Employer-employee relationship. And my
That
lord,
is different.
other, my
He
lord,
was subsequently appointed on regular basis. He was appointed on regular basis. Then he claimed, no, that period, total period I have to get. And that was given.
so far another judgment, our High Honorable is there, my lord. 16 years family pension given.
16 years
As road.
without regularization.
Yes, my lord.
Oh, this rule is not applicable to us. This central civil service rules. Next. I'm still waiting to allow the repetition. Give me something. Okay. Maybe you're tired. Have your nice something. Come back at 2, then we will try. Yes, Mr. Doctor, what brings you here?
Item number 15.
Hmm?
Next. Then the farm accommodation next week.
Oh, that crown for Mr. Doctor cannot be. It will not look nice in the order sheet. Just have to smell, that's all. The brief or the accompany thing to the brief. Accompaniments to the brief.
It takes time.
Okay, then okay. Mr.
My lord, Mr. No saw him, but yes, there.
Where is?
Next week, if your lordship.
Okay. Okay. On the prayer of Mr. You are for the petitioner,
I'm for the respondent.
respondent. On the prayer of Mr. S. Dr. Leonard Senior Counsel, who submits that he has been engaged only yesterday evening, comma. Mr. S. Dr. Leonard, Senior Counsel, submits that he has been engaged in the matter on behalf of the respondents only yesterday evening and accordingly submits that the matter be taken up on 26/11/2025. Prayer is not objected to by the learned counsel for the petition. Accordingly, registry to list this matter again on 26/11/2025. Mr. Swans, assisted by Mr. K. Kolita. K. Kolita submits that Mr. S. Dr. Learned Senior Counsel not be briefed properly and accordingly prays that the matter be adjourned today and be listed on 26/11/2020. They are not objected to by Swenson.
My lord, 27/5/15, your lordship appear in
Where
this case.
10,000 rupees cost. Where
27/5/15. When we challenge that, my lord, notification, your lordship was also there, my lord, along with me, my lord.
this matter before any other bench without me. Passing, yes, yeah.
Oh, bless my lord.
Lordship, next item.
That is the beauty. Next items after 1 o'clock. After. Okay, you're fit and fine, young counsel. I am not. You're fit and fine to stay here till 2 o'clock. No. A Saraf, learned counsel. Yes, something.
Item number 29 from Delhi. CGC, Mr. Gogoi also. Will take more than a minute. For the disciplinary proceedings are supposed to be brought on record by CGC. They are brought on the record, then we can start, we can fix for a hearing from next date onward.
by the chief engineer. Thereafter, and yes, Mr. Have the records. The charge
Court martial case. Last year, October. My just request is that
what has happened has happened. We go back. What
Oh.
is the charge against you?
charges I will have to prepare. But just he has been dismissed from the service and he has been sentenced for
What
1
is
year.
the allegation against you?
Allegations for violations of the order and the communication, breaking the chain of command, communication chain of command. I was a commandant, OC of Assam Rifles. So I just flagged certain, I was as a whistleblower, I flagged certain violations which were financial irregularities. I intimated my senior officers, they did not pay any heed, so then I went ahead. And because of that, since now they have put allegations that I have violated the chain of command. And because the lordship, anytime, let the records be on the record, let the
Yes, the
records be
records.
on the
We can-
record.
If you can
The-
wait, we'll finish this.
As soon as possible, you give me a date and then I will.
If you are required, we can.
Lordship, it will not be possible for today.
When do you want it? You give me a date.
Shortest possible day. After 3 weeks. I have to come from Delhi, sir.
We'll have it in the new year. When? 6th. After vacation. Bihu. Holidays from
20. Fine, sir. It's fine. Advocate KK Singh.
on. This is item
29.
for hearing on 20.
I would request CGC to be present. Because I will have to come all the way. Just because it's very
Mr.
busy.
Council, yes.
Obliged. Obliged.
This prayer was made somebody
Obliged, sir.
or they know.
So kind of you, sir. So kind of you.
I think you have got the message.
Welcome, sir. Welcome.
Kilisha. Which will it? Puso. Our subsidy. In the manner required. And of the subsidy. The petitioner that was permissible. Clause 3. The petitioner was released with the had in its meeting. The both in the affidavit reading of the set a precondition has or being extended. For the period, it had our subsidy was a functioning unit. the the amount involved. Was Honorable Supreme Sukumoy had held that is that this order. The above observation. D. Upabanyu, learned standing counsel for the day. Post up. Inform the other side. Okay, we'll do that. The ground that he is feeling prayer accepted. Leave. Not see you here again. Take rest.
Your Lordship, give permission, I have filed somehow the affidavit by the petitioner today. One, I also filed, my lord. For the, my lord, order by the chief engineer, that portion,
Mr. Goswami. What's that order?
not entirely quashed, but that portion of seniority.
We can't. We'll.
Now, my lord,
Okay, tell me, what is your
yes, page 112, paragraph 6, may kindly peruse.
page?
112, paragraph 6. Because of this incident, the chief engineer has not mentioned in the affidavit, my lord. Why this petitioner seek request
There
to
may be 100.
compelling life-threatening because her mother and maternal uncle was shot dead, and she was got injury, serious injury, and this office was proposed to be shifted to Udalguri, where her house was there in 2000.
So
When
you had this order of the chief engineer before you.
Because my lord, they,
No, you had the order of the chief engineer before. Did he had that order? If she had any grievance, why he had not? At least when you filed this writ petition also,
my lord, what happened? Subsequently, the executive,
that order is nothing, non-est.
because it is on the basis of the High Court's order, my lord.
What is the High Court order?
High Court
Directing-
order to give seniority.
Consider.
Yes, to consider accordingly
Who is he
considered.
who is he to consider?
Whoever may be the authority, my lord, the rank
He will
hierarchy,
rectify it. Don't worry.
whoever may be the
We are
hierarchy, my lord.
rectifying it.
Whether it is chief
Anything
engineer,
else?
then why this chief engineer not pass this order, my lord? It is the duty of the chief engineer to rectify that order, because this petitioner cannot do anything. Whether the petitioner can say that, my lord, your chief engineer should pass this order, it is the authority, my lord.
Can't tell the chief engineer. I'm not below the chief engineer.
Definitely above. That's why the order passed by this honorable High Court, where it is.
Okay, let us see what is the order of this court.
Yes, at page, my lord, 100. High Court order, my lord. Yes. Starts at page 117 and relevant, where, my lord, chief engineer, executive engineer, superintendent, all were party. What direction was given to sell
100
120? Last part, it is 2/12/2006. 2/12/2006. Last part,
Hmm.
the third line, the authority shall consider the petitioner for continuation of in service for all purposes, including seniority. And this order was,
The whole thing.
my lord, last 3 line, my lord. The authority
Okay, read that having
having regarding to the facts and circumstances of the case, the writ petition is disposed of, calling upon the response to state to dispose of the representation dated 12/10/2000, then 2 months from the date of day when a copy of this order is served. In accordance with the provision of law, the authority shall consider the petitioner for continuation in service for all purposes, including seniority. And on that basis, my lord, in December,
direction was issued.
yes. Respondent, they. No, my lord. No,
That this direction
no,
was.
my lord, the superintendent engineer, chief engineer, all they are party.
It is state
Yes,
government order, show me. Where is the order passed, consequential order?
this is the department, my lord.
Page 35 of your writ petition.
Then, my lord,
Okay, let us see this.
in the executive order may kindly peruse. Order passed by the executive
Ah,
engineer.
that's what I'm saying. It
Yes, yes,
of the
yes,
Honorable
yes.
High Court order.
Yes,
The services in favor of so and so hereby regularized for all purpose,
including here.
effect from 23/5/1990.
Yes.
Okay.
No, my lord, this is on the
The
basis of the
pay
High
and
Court's order.
allowances of for the entire period petition. The original of this out of service will be disposed of. Allowance will be debitable of
Also head.
account 2702.
Yes.
Now show me that after this order, you were released with the pay and
Yes, my lord.
where is
is
your
done.
statement?
This was done, my lord.
Where was the statement? Where is your statement to that effect? Your statement in the writ petition, is this order was kept hidden.
Yes, yes.
Where was it implemented? When?
Subsequently,
No,
not
no,
immediately.
Mr. Goswami, it's a very simple. This lady to change and every day.
Nowhere since she has said
Then show
anything.
me, show me. Last date, I clearly remember that this document, your case was that
Yes,
this
yes.
document was never issued.
Yes, my lord. What happened?
But where is that?
This
that
private, my lord, I have stated in my affidavit, that private respondents who 6, 7, and 8 were in the establishment department, and this order goes against
So show
them.
me, show me
Yes, in
This
this affidavit, I have stated
was released to you. Show me.
that part, my lord, I am not affected. This is the department, they have released the money subsequently, my lord.
Where?
It-
When?
my lord, that date, today I cannot say.
That is what we stopped last time.
But
That is the,
it is,
that's the only query I put to
no,
you.
I am not affected for that, my lord.
Not
I am affected. No, my lord, I have these compelling circumstances when an order was passed for
Okay.
transfer. I should not have lose the seniority because my maternal uncle and mother was shot dead, and this petitioner was, my lord, got serious injury. She was bedridden for 1.5 months, my lord. Therefore, how she can go? This fact has not been stated by the chief engineer in his affidavit, my lord. Very serious, because I am, and the transfer, in fact, this shifting of that office was cancelled earlier, then, my lord. They proposed to transfer the office of the my lord, superintending engineer to Udalguri. In this Udalguri office, my lord, the house of the petitioner was there. In 2000, I have annexed that super SP's, my lord, letter to the deputy commissioner. That, my lord,
Join,
95.
huh?
First appointment is
No, no, no. When
2025.
did you join this place? Pursuant to the
2006, my lord. 95, first or Dhansiri. Yes, yes, Milord.
Did you join?
After 2/4/1998, Milord.
When? What is the date?
Put the officers are in the same campus, Milord. I have not got any other benefit because the irrigation department, same department. One is superintending engineer, another is Milord executive engineer. From superintending engineer to executive engineer, we did the same campus at Moldoi. Because they proposed to shift this superintending engineer office to Udalguri, where the murder of the petitioner was shot dead in her front, Milord. Maternal uncle, 2 persons were killed, Milord. So how she can go? Then when this proposal was given, then petitioner written one letter to the chief engineer, Milord, that I should not be transferred to Udalguri because of this incident. Then Milord, petitioner this chief engineer passed that order in 2005. Then
That of this court. Directed for that. Right? You got your salaries. No dispute on that? Now, when were the
5, 6 and
5, 6, and 7 first time? When was the Sile
have annexed it, Milord.
there?
Annexer, Milord, page 40,
42.
yes, 42.
Thousand seven.
2007, yes. Yes, yes. Yes, yes, yes. Lordship, Lordship. Lordship,
If we come
32. 42, yes, Milord. Is at serial number 6.
admittedly, she is below 7 and 8
Yes,
respondent.
yes.
What have you taken? What's
3, 4, 5. That's why, Milord, I have representation also.
where is that representation?
Yes, page, Milord. Page starts from, Milord.
You got it immediately, this one?
Yes, yes. At page 54.
What is the date of this?
22 10 2019, Milord. 10 2019. Yes.
LBS. Settled position of sin. Cannot be still an order at there is a question.
Lordship, Lordship. That's a thing your Lordship correctly pointed out. But
Mr. Goswami, we
when
know
my
that.
lord-
We know Mr. Goswami.
Lordship, Lordship.
So 7 to 19, the development which took. Whereas the Also you are back. Now you come before this court. So this representation,
Ever repeat,
everything. Everything. About degradation 7.
there are only few representations. Definitely not Milord, but will have to challenge. I agree. But Milord, what happened? When the High Court's order is there,
Thing.
yes,
Then
that's
why
why
have you
Milord,
challenged your place?
maybe if we- might have filed because
No, case. Yes, High Court directed now you cannot keep me.
that representation, because I cannot say anything because
Got it.
she was Milord.
Not put you into more trouble.
Lordship may kindly peruse the annexures because this executive engineer may be below the chief engineer.
We give you that. We give you seniority from. It is the implementation. Not implemented.
That is the department,
2007.
Milord.
2007, you knew that it was not implemented.
That is the department, Milord.
Oh, why have you not challenged? Department, I can't put them to what they position they are now enjoying. I can't. No.
That part of instruction I have not. I'll have to check, Milord.
You need not. We'll trouble you any further with this case.
No, Milord. In
But
fact,
the learned counsel.
Monday, Milord,
Tomorrow.
or Tuesday, Milord. Tomorrow I have some
You
other.
did not be here. I kept it only for passing of the order. 2-3 orders I
Oblige,
passed now.
oblige.
I voiced it.
Oblige, Milord.
Tomorrow I
Oblige.
pass you, Mr. Goswami, not be here. We'll take care of. Namgita Likilo was over. I'll pass the order.
Other,
instead of
Milord,
it.
one thing. Regarding that, Milord, rule, chief engineer has stated that
Come
establishment.
to the
Yes.
district.
Yes, yes. Yes, yes. They have complied.
Every establishment independent exist.
Independent.
Came from Mongoldoi to Dalguri. No,
No,
Huh.
in the Mongol
Mongoldoi.
same district, same.
Two officers, two different officers. So two different officers, you have different units. If it is two different units, at bottom
This
seniority.
establishment. In fact, this board establishment is not here. I want to submit this because from the date of joining, 11, rule 11. Yes, I have examined, but here in the rule, Milord,
Rules we have interpreted.
Lordship,
I'll pass the order tomorrow. You'll get it to.
oblige, Milord.
Yes, yes, yes. He informed me, Lordship.
When should we will keep
Your
it?
Lordship, please, I need it. I need
Vacations, any problem?
old lady.
Yes.
For the deputy.
What is your instruction? Why has done the course?
Yes, Mr. Ortega.
Sorry, Lordship, sorry.
Let's already take your place. Yes.
Sorry, Lordship.
Yes. Why are you continuing as a sub?
Exactly. The matter we have not dealt with. Refer to my
That
learned
is
friend.
standing order. He has complete. Material employed.
Just referring to this provision, it's page number 18. 18.
Are classified here. Not a compactized.
Referring to him as
Compactized.
Competence. I have written everywhere, so I am a minister. Hey, to,
This is which force?
Inspector,
CRPF.
Inspector.
CRPF. Sorry, you are a-
Ministerial staff.
patent. Filed a review medical board examination.
Page 70.
They have also rejected it.
No, they have placed me in P5, permanent Lordship, P2 permanent. Yes, but the rule says that
Okay, okay. Where is that?
shape is page number 80, 81, Lordship, 5.3.
Validation provision.
5.13, then 4.13, 4.14. 13. Written there, seniority. So this
Any other medical departmental medical report?
is 46. 46. It's 46 by elective specialist. So over the signature, no. For that also. At page 44 also. RPF authorities. Is page 31. No cardiologist is there, not implanted. Page 40.
Is 11/4/23. referred. What was done on you?
temporarily,
That is at page
35. Thir- 35, left side, bottom left. Left side, page 35,
T4.
lordship may directly come to
To the MCH.
no, this is after. Lordship. All are subsequent. Placing file the appeal in terms of
Where is your appeal?
that is at page 59B. Then they recommended for the review. Authorities forwarded. Page 59. The RPF. And lordship may come to page 66. At this order, they have constituted a review medical board. Page conducted at page 70.
Who are the doctors who did that?
Yes, lordship, that is page 70. The shields are there below. Left one, psychiatrist, then surgeon, then medicine, no cardiologist. And Delhi High Court, lordship, I have placed that when cardiologist is required, event field. At rule 15, it says appeal, that relevant should be there.
Regularity, you have denied him. Then who will compensate that?
One, having a cardiologist review. Para 15 says that specialist from relief must be associated maybe from within the organization or outside the organization. May I say that it should be outside the organization because
That much we can't give you.
some influence may be there because senior has already lordship.
It's dates
Yeah.
where you first detect. Referred.
I was referred first on 11/4/2020. I fell ill, then I was
MCH.
to GMCH lordship.
Then
Then lordship on 12/4/23, On 12/4, next day, that heart problem was detected at GMC, admitted at GMC, then on 13/4/23, implanted pacemaker. And on 24/23, released from GMCH, Lordship, and with an advice to 1 month rest and review after a month. Thereafter, Lordship, on 24/23, CRPF doctor categorized me 34.
Opinion of the doctor.
Is 35.
Where is that certificate?
That is at page 46. 6.
That is subsequent.
That is subsequent. 20 April 2023, notice I was released. Then 24/4/2020, CRPF doctor categorized me as P4, T.
So not a cardiologist, medicine. Then
Page 35. Then, Lordship, as advised by the GMC, I went to the GMC for Lordship review at page 39. Then and the review, Lordship, I was declared fit to resume duty. And medicine also stopped. That is 17/5/23, page 39. The certificate is there. Then again, Lordship, after that Lordship, I was reviewed at the composite hospital Guwahati and recategorized me as P upgraded from P4 to that page 41. 23/5/2023. It is 22/5/2023. Again, review medical board categorized. That is number is 29. That is 42.
well, now you became T.
Yes, T20, P3 only, P3 only. Then, Lordship, again, I went for 44 GMCH, and it certified that I should resume normal duties. I should continue for normal duty. Twenty-two 11/2023. And in between this, then I was sent for the promotional training from 1/1/2024, 15/1, at page 48. 48. Page 46, that don't go for that. For restriction of normal physical Seven Lordship. Again, GMC time also said he can continue all forms of physical work. It is there. As page 57. He can continue all forms of physical work. Advised to come to up so and so, so and so. Lordship. And thereafter again they have put me (23 9 24). Approved on 23 9. Then thereafter I filed the representation. Appeal at page 59B. 18 9 24. For that Lordship, the senior that promotion list was published, wherein I on 8/9/8/4/24 promotion list. Wherein the person and Lordship, I filed the appeal Lord at page 66, got the appeal and what for constitution of a Lordship, that in terms of that direction Lordship, that was conducted at page 70, it is there. Then I have been placed permanent category P. Page 70, 70. 66 is the order, Lordship. Yeah, yes, 67 is the order. 66 is the reference.
Yes.
Then report comes in.
Get that P2
at page 70. Then Lordship, may I of the PPI implantation in a cardiac normal pacemaker only. Then medicine space second. Then recommended category P2 permanent due to one AV implanted.
Chaudhary.
Lordship. Yes, Lordship. Lordship, AR Tohbillar.
Oh, sorry, AR told you. Peti- being admitted into the requisite a said development taking place. Because of the cardiology department of Guwahati Medical College that he is the GCH authorities also was then ex- comma the response is in which is or con medical board for const for co- accordingly while office medical superintendent constituted a or the review said examine review medical bracket ministerial. Facts as noticed was detected now being the position. This court would now of the office order dated to related health issue, comma, the said opinion on the periodical view of the petitioner after being implanted of the Guwahati Medical Office had found the petitioner physical to any form of work. 31/1/2025. Basis for his Victor. Provisions existing in the found fact that the being so rendered by a board
By the ratios and
by the with the red copy. Blocking his con
date, Lordship,
what is it?
that should be 7 to
7 to 25.
permanent. He has been placed in permanent. 7 to 25. SI to in some,
ASI to inspector,
should be SI to inspector, not
SI to inspector, sorry.
like that.
Mr. Majumdar.
One matter is the hearing, my lord.
Eight, 39. Heard this matter.
Lordship had the occasion of hearing this once, my lord, and your lordship had called for the scanned copies of the order sheets of that case, my lord, for court case. This is before your lordship now. And thereafter, the hearing has not mattered.
When its urgency is there, you have an. You have to free up, Mr. Yes. Yes, what is the position, Mr.
So far,
Get the writ petition, show me the. The affidavit, show me. Document. Where has he admitted? Where is? Okay, show me. Much only.
more meters are there, my lord. I'm just reviewing one by one. Paragraph 10. Ex DGM CL. An instruction of the then. Had been duly authenticated.
RD statement available in. Maybe. There in the inquiry. Forget this. These are all subsidiary. That is no admission. I'll finish. I'll
Prior to date, my lord, once
Arey, Mr. Samaria, where is the material in your inquiry? I don't want anything else. We can't have the satellites. I want the Jupiter itself.
my lord.
I want the satellites of Jupiter. It was going on, it came to an end, you imposed the penalty.
Yes, contested, no doubt.
Show me. Those statements, those are.
Yes, my lord.
in a more better manner. Unfortunate. Basis of the admitted.
Query, my lord.
Show me. Uh,
Yes, my lord. File on 7.
the records. Very minute statement. Examination of witnesses. I also have. From you. Who has given you this file, Mr. Where is he? Sir Branch. Ask him. No record, no inquiry. Thousand 13, the file. When did he file his reply?
Lord, but so far
Not accept. You have filed an affidavit. Where did you file that affidavit? That many things in the inquiry. She said that. From where are you saying this?
one date, my lord, I
Visited. We have visited.
no doubt. Again, my lord, in writing.
That record is not produced before me. What you said in the yeah, Lana Council for. But what do you have to say?
My submission.
Chamoria, we have. Yes.
Reject.
Who is for the
Service is complete, my lord.
there is a pipes, so the
Please.
payment. Stop the pension from today. Clarification, you want some clarification? The record is there. Give it.
My name is Rina Khan. Service record of the deceased
This orders, pension order without the service book. And you cleared it. Not paid.
it shows that paid.
Hey, you have released, you said you have released the amount in the affidavit. Consult your affidavit. I may be wrong. File to deduction.
Paragraph 9, my lord, in the
No, today.
Yes.
Passing bills,
Yes,
pension order without service book. Bah.
Yes, 50, my lord.
We are noting that. Next time you come and make an objection, we will impose a cost on you.
Yes, 50, para 9, my lord.
No, if this is your material, how can you have further material? It's your material, how can you have further material? No. Herein, let's see. Inviting a reference to your letter on this, I am enclosed here with pension paper of Tilak Chandra's count, forwarded by the additional deputy by letter number 2015. Now we have opened it. We have opened it. Here, Rina count. Now, where is the, have you inquired where is the nomination person concerned? Whether he had made any nomination?
137.6.
Young, because I have called for only call for this one.
The Borua is there, we are sure things will. Yes, if this is your total paper, sorry.
Today,
The C. Borua, Lanark Council for the bracketed A and E are. Ten, 10, 12, 20. Borua, if this is the manner, oh, they have sent the pension proposal now. But Mr. admitted that you are the second. You have admitted you are the second wife.
My lord.
You admitted before the
In my
tribunal,
objection,
before the,
yes,
then,
not admitted. my-
yes, you have admitted and you have, both of you have agreed. Now she is not paying you.
No,
She is not
50
paying you.
50-50, my lord, I have got it. That
Then
part,
what do you want?
pension part, my lord.
Pension, but she is not giving you. Go and file a case against her. Why you are become to this court?
Because the order has been passed by my lord AG, that's I have impugned in.
Will give to 143 one man.
Yes,
Already held to be the first wife. No,
but there is no any declaration, claim to be, my lord.
no, but after the tribunal order,
No, no,
after the Lok Adalat order. Huh? You come
Yes.
there,
Page 30, my lord,
you come, I'll show you.
36, my lord, is the relevant part. 35 starts.
Wife, second wife, it is written. Second wife of, come, 2. 34. It's 33.
Yes, my lord, 30.
3.
33, my lord, it is not.
Second wife of Tilak count. You accepted this. There is your dispute with regard to that. You have not disputed that position.
That is. But I have raised objection in that proceeding. Subsequently, that application,
Mr. Sharma,
yes, my,
your second wife.
but the application has
Any
been,
minor child?
right now, no. But they have attained majority, that part is there, but the 137, my lord, that nomination part.
Order hearing, go idea. Mr. Sharma, Burua, you need not bring in. What deal on a council for the party? However, the hearing remains inconclusive.
But
The records produced by Mr. by him till the next day.
that part, my lord, regarding who is the nominee, my lord. If
Before the,
my lord, the nominee is, my lord, in my favor, then that petition has been filed by the, my lord, the resolution number 9, my lord.
accepted, you went there and
But
compromised.
order, in the order sheets, my lord, it reflects that. But in the,
Compromised.
it compromise is there, my lord. But the petition has been, it is reflected, my lord, in the order itself. That petition has been
Mr.
filed.
Burua, sorry, you did not do anything. We'll consider this your prayer on the next day.
All right.
I'm extremely sorry, I missed.
The prayer of Mr. D. K. We have now 2 K. Kolita. Yes, Mr. Khan.
Initially, it was allotted, and just after 2.5 months, the allotment was cancelled. First, SDLSC resolution is at page 16.
Oh, that land.
Yes, Lord.
Not in your favor.
Yes, interim order is.
The land was given to the respondent number 6.
Six. That is the
So
private,
Hussein is appearing for it. Yes,
Pri-
what is your better claim here?
is the respondent number 6 is the private school.
That's Rainbow School.
Not.
Yes, what is your better? The subdivisional thing. Taken to its logical conclusion. Order for allotment premium. Between that only this was changed.
Yes, just after 2.5 months,
Yes.
another resolution was taken.
On the prayer, we'll have to go through Mr. Gusar. He said he has filed the affidavit, he has the records. Not go before that. Why the review?
Report that has been. I have the report.
To the petitioner there.
Refer to division bench matter, my lord. Same issue, my lord. 7th of November. That day, my lord, it was timed out, left out. So may I pray, my lord, let this matter. Order, yes, one.
Releasing.
No, my lord, let it be part of, my lord. On first week of December, my lord.
Yes. Who? Here. Why is the absence? In Hindi, he does not understand. Eleven, 12. Now I can't even give. Yes. Happen. Regular pension.
Are indented.
Yes. After the vacations.
Application. If my lord, the short issue found whereby my SLC, my lord. Honorable court interfered the aspect of the matter, my lord. But again, my lord, SLC rejected the same ground, my lord. My lord, in this
There is, So your initial case was
mother applied, in the meantime, my lord, somebody else.
Dar Mahrabuddin projecting to be
Definitely, my lord. Kindly have a look, page, my lord, 22, my lord. Last paragraph, my lord. Last paragraph, my lord. And operative part, my lord, direction part is, my lord, in the next. Yes, my lord. It was found, my
appointment was not touched.
as a procedure for appointment, my lord. But here, my lord, it was found that, my lord, it should, my lord, terminated and direction was given.
Where is that? Where is that termination?
Page, yes, my termination is, my lord, next page, my lord, page 24, my lord. This man was, my lord, Abu Bakr. He was terminated, my lord. My lord, here, my lord, one important, my lord, here, my lord, lordship, kindly I refer, my lord, page 23, my lord. Here it was directed to consider section circumstances, consider mother or son, my lord, because initially mother applied, my lord.
You have placed the,
Yes, my lord. Yes, my lord, because
this is not that you have been, you were selected.
selected, my lord,
But-
thereafter selected.
For respondent number 6 was terminate him, appoint him. That is not the case.
Not the case, my lord.
So again consider.
And again, consider, my lord.
Then
and
what happened?
Then, my lord, he was recommended, page 29, my lord. Recommended, my lord, his, yes, my lord, the first one, my lord, PNRD, my lord. Now, my lord, thereafter, what happened, my lord, as per page 33, my lord, it was forwarded.
Your father died?
Father died, my lord, 1997.
Can you be considered for a vacancy of 2?
Yes, my lord. It was my lord,
Yes,
their,
okay, then
their
what?
mistake, their, my lord, corrected one. Then, my lord,
What happened?
then DLC, my lord, I enforced to my lord, recommendation of the DLC. I approached again before this honorable court, page 36, my lord. Page 36, directed, my lord, operative part, page 37, my lord. Of the above and having regard to the facts of the,
Done, done,
Done,
then
my
what happened?
now, my lord, SLC rejected, page 39, my lord.
39.
Yes, my lord. My lord, it is dated, my lord, page 39, it is dated, my lord, 19/8/2016, my lord, rejected. Then I approached before this honorable court, my lord, page 41 and XR 9, my lord. And this is the, my lord, detailed judgment, my lord, page 42, my lord. Relevant portion of fact is, my lord, paragraph 3. Lord, was detailed discussion, my lord, and this delay aspect, my lord, particularly, my lord,
16 is the operating portion.
yeah,
Page 40.
my lord, this delay aspect, my lord, was specifically dealt with page, my lord, 47, my lord.
Okay, then what happened?
Finally, my lord, this observation, may I read out? Paragraph 40, yes, my lord. It was held that, my lord, normally delay should be, my lord, appreciated, but peculiar facts and circumstances, my lord, it was rejected. And it was directed, my lord, to reconsider by the SLC.
Where is the earlier SLC? The earlier SLC?
Earlier SLC, my lord, whereby it was rejected, this is, my lord, page,
Round?
my lord, he was minor. Now, my lord, on the same ground, my lord, now, my lord, lordship kindly will look page 49. It is,
22.
yes, my lord, the 11 portion, my lord, his name, page 56, my lord, Mehrabuddin, on the same ground, my lord, delay. But I beg to, my lord, refer, my lord, to judgment. It is,
And in 21, the director,
my lord, first
this
one,
has
I
been
have,
done
my lord, for
and
two,
this has been.
too short, my lord, I have, my lord, in judgment, my lord.
What is this?
Yes, my lord, this is, my lord, regarding, my lord, res judicata, my lord, paragraph 33, 34, and 35, my lord. Thirty-three, my lord, it is the, my lord, two old judgment referred, my lord, very. Because, my lord,
Then
paragraph
1986.
34, my lord, 34, my lord.
We have seen it. We have
34,
seen
my
it. We
lord.
have- Next one.
Next, my lord, paragraph 20, my lord. Para 20, next judgment, my lord.
And what?
Only, my lord, I am point, my lord, this is issue who, where,
Not a res judicata. Who is dismissed? Never dismiss. Have a fresh cause of action. Res judicata, you do.
my lord, only thing is that, my lord, I am applying, my lord, for them, my lord, because, my lord, issue.
Then what is the Delhi High Court?
Delhi High Court, my lord, it is, my lord, Delhi High Court, my lord, paragraph 21 and 22.
Res judicata.
Yes, my lord. Then, my lord,
Dismissing your case on res judicata. We are not.
then, my lord, paragraph, my lord, 15, my lord, judgment 4, my lord, 15 and 17, my lord. Then the coordinate bench of the same High Court.
And how is it applicable?
Because, my lord, I am on principle.
Detention under the.
I am on the principle, my lord. That, my lord, this delay aspect of this matter on the peculiar facts and circumstances,
Okay, done.
my lord, it was held that-
Default fail.
Yes, my lord.
Then,
Then, my lord,
Trilok or not?
yes, my lord. Then, my lord, another judgment, my lord, judgment 5th, my lord, paragraph
Judgments
31, my lord.
burdening with our judgment.
Kindly, my
But
lord,
Mr.
But your lordship is satisfied or not satisfied?
I'm not satisfied. I'm dismissing.
Look, kindly, my lord,
I'm only satisfied that Mr. Barbhaiya will not be put to difficult.
only thing is that, my lord, my case is that, my lord, if, my lord, on this delay ground, my lord, this honorable court, my lord, with a judgment, because this person is entitled to compassionate punishment, or it is all, and therefore one person is appointed to this family, my lord.
We are now going to put the matter to rest.
No, my lord, because the, my lord,
We'll put the matter to
legitimate
rest.
expectation, my lord, one person, my lord, so long, my lord, is surviving on this, my lord, that should be also,
That
my lord, look.
expectation unnecessarily has been lengthened.
No, my lord,
Why?
because, my lord,
Because
he,
of this
he,
proceeding.
my lord,
We'll
with
not
all
do
the
that.
lordship, kindly.
You have
kindly-
said the correct thing. The man is
My lord,
living on hope. We'll
my lord,
does
with
that.
a legitimate, my lord, he is consistently, lordship, his first application, lordship, kindly have a look, my lord. It is a for, my lord,
But Mr. A.M. Barbhaiya,
it will be, tomorrow I have some problem, my lord. On Monday, my
not be, I'll
lord,
pass
it
the
is-
order.
it is part of it.
I will pass
No,
the
my
order.
lord, kindly, my lord, I have some problem, my lord. Kindly,
If
please.
you have problem, please don't come. Heard you, I'll pass the order.
Kindly, I may be hard, my lord, in whatever.
But I've heard you. I've heard you.
Yes, my lord, a long time. my
Compassionate
lord, with
appointment, more than this, we are not going to.
Already appointed, my lord. Somebody else, my lord, snatched away, my lord, by theft, my lord.
Did my judgment. This is not last forum. Higher forums.
Delay ground, my lord.
There are higher forums. Then Barbhaiya is a very,
I don't know anything.
don't know anything. Then we will try to,
Learning, my lord,
we'll
learning.
try to help you out by writing something in the judgment. We have a duty for that also.
Learning process, my lord.
When
This is another, I
97,
understand, my lord. But
the
because
court
the
does not have compassion. That's the problem.
one person, my lord,
Yes,
is
yes, yes.
expecting
Next one,
consistently
next
fighting
one.
for somebody.
Barbhaiya, there is a limit sometimes. We are there with other matters you come. Yes.
This is regarding termination, illegal termination,
That
one, my lord.
Yes, Mr. You want to argue this? But Mr. At 2 p.m. Oh, satisfy me. Giving you an opportunity. Sir, does
Hey, please, your worship, my lord. That matter, constable, wherein, my lord, he was the persons, they were,
oh
sir, like that, my lord, there was a recruitment exercise out, wherein,
Anderson,
yes, my lord, the son appeared, my lord. The specific allegation, the petitioner, there is nothing.
yes, why have you punished him like this?
Exerted pressure at a,
Lordship.
the hearing, my lord. Lordships, on last occasion, lordships heard this matter
No.
and directed the respondents to produce. Direct to be produced.
Records have come, no?
Lordship was pleased to direct it. Yes.
Record, original. Records have been received. Madam, doubt, if there is nothing. There is a doubt, then yes.
Much obliged.
For this, we give you liberty. Prescribed by the scheme.
Yes, ma'am. No, ma'am. Yes, madam. My lord.
Lordship have received instruct the petitioner as the application.
Yes, yes, madam. Yes, madam.
Is the appointment not coming? Consider that is a different thing. You will have to. Why? What is the explanation? Okay, judicial. Financial. So judicial will send it to personal, personal will send it back to judicial, my man will be suffering, lady will be suffering. Plus jargon. Is at the same position. Like this, madam.
And Malan, then they will take the plea of delay, Malan. And Malan,
Then
the-
they'll come before me, I'll say,
This is their
what is
version.
your SL? That means SLC and DLC is not by the officers, by somebody else. That what you want to indicate? Oh, that. Last time they were somebody. Okay, 28/11. As agreed, Rana. Yes, Mr. Das.
My first representation is
For further here. Golda, just give me all the facts. Yes. Yes.
Should this any detail or something?
Have it after vacations. Not
Regular civil. Pattern, my lord. Then it
But
may
again,
come after.
this matter will not be treated as a and or tied up matter. Had enough. Right, then the
Then it may come, my lord, after.
whatever disposal.
Regarding the authority of the circle officer to pass an order in respect of the Kamrup Rural District Lordship. Lordship, that is clear. Page 188 of the affidavit filed by the government, Lordship. Also, Lordship. 188. Lordship, column 3, copy 2, Lordship. This order was passed Deputy Commissioner and District Register of Citizens, Kamrup Metropolitan. Circle officers Sonapur, Chandrapur, Dispur, Guwahati, and Azra. And 25 to affidavit filed by the government, Lordship. Respondent 5.
Subdivisional officer, Kamrup Metropolitan.
Excel 1. Case 188, Lordship. I have not found specific.
Very good, very good. This is your case. This is
Lordship,
your case
Lordship has asked
that
me.
he had jurisdiction to, because that copy was given to him.
Hazara Circle
Dekha.
is. He has asked me that query.
That's
why.
the answer you got. We are
that's-
finishing, you know.
Hazara
Mr.
Circle.
Kolita, you have read 3. Huh? You have read 3. Provide the copy of the all BLOs under their respective jurisdiction. That he is under his jurisdiction. Just show me that.
He has asked me that query. Because
this is a collusion.
Also has been.
there is no so-called Lordship. Ultimately, this proceeding has not initiated. Because the rule 9 not followed, Lordship.
We'll direct them to follow rule 9.
In the meantime, retired, Lordship.
Yeah,
2000.
Then 21.
Pension as well.
Block level, na? Block level?
Level, boot level.
Level, official.
Hearing, Lordship. Sir, he has received any pension.
I have one item number 30.
Yes.
And process has been carried out. Rule 10 to Assam Discipline and Service.
Very issued with a show.
No, nothing.
Yes, madam. How do you do this? Seems to be hurt by.
Lordship, a wrong interpretation, in view of the wrong interpretation of this honorable court order, this order has been issued. I have annexed that order also. Next page. 30. Lordship, in that case, this honorable court has interfered with that order. Similar order was
Fix
passed.
it next week.
311. Holding the inquiry. But without issuing a notice,
Yes.
where is that notice given order? This is the only order.
Yes, page 28. Delegation, Lordship,
Elaborate on that. Madam, what is this? But Mr. M. Khan,
already affidavit filed. already evidence.
Make her submissions in the matter. Pass the order if you want to.
As a part
Get
of,
the judgment, 311.
I have annexed that order.
No. Supreme Court.
The inquiry is not practicable in that even only.
Inquiry.
Yes,
Inquiry is not practical.
practicable as per the provision of law. That is the part of lordship. Obliged.
30, it did 30.
No.
Submitted a written argument also.
I got it. Bitot committee, sir. And I today know I got over first minute. I heard Mr. BJ Ghosh, Lana Council for the petitioner. Also heard Mr. SR Burwa. Due to paucity of time, the matter could not be taken up today. Parties have expressed urgency in the matter accordingly. Registered to list this matter again on 25/11/2025 for hearing. Hearing, na? Hearing. So matter be not tied, matter be not treated as a tied up and or parted matter before this court any further. 25, I said. 27.